give testimony. If you could introduce your witness, please.
Good afternoon, Mr. Busher. Can you please state your full name for the record?
My name is Michael J. Busher.
And what is your occupation?
I am a landscape architect and land planner with T.J. Boyle Associates.
Mr. Busher, do you swear or affirm under penalty of perjury that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Well, thank you.
The witnesses who will be cross-examined. Sorry about that. Mr. Busher? Is that how you pronounce it?
Busher.
Busher. I wanted to start off by asking you about the opaque mesh screening that you referred to on page 2 of your report that's dated August 9th, 2018. You indicated that certain portions of the fence would be covered with a partially opaque mesh screening. What portions were you referring to?
To the best of my knowledge, those portions haven't been specifically identified. The opaque mesh screening was proposed by the petitioner and Mark King as the original main aesthetic consultant for the petitioner in attempting to anticipate certain mitigation elements that could help the project.
Okay, so you don't know whether it's going to be on the entire fence or just different areas of the fence?
My understanding is the intention was not for it to be around the entire fence, and that the applicant or the petitioner is willing, based on a potential post-construction review, to evaluate where and if that's one of the better applications of mitigation treatment.
All right, so what you're saying is we don't know yet and we're going to figure it out later? Fair to say?
My understanding is that the petitioner made several attempts to do outreach with adjoining property owners.
Excuse me, could I ask that the witness be instructed to answer the question? I'm not asking him about what he understands about conversations between the petitioner and other people that live there. He's trying to answer the question and put it in context.
Please re-ask the question.
Can we read it back from the record, please?
So what you're saying is we don't know yet, and we are going to figure it out later, fair to say?
Your answer?
My understanding is that the specific locations for the opaque mesh screening has not been finalized or specifically identified.
Does your aesthetic analysis incorporate the notion that this opaque mesh screening will or will not be affixed to the fence around the project?
It has taken the possibility of that mesh being possibly part of the project.
I don't understand how you can give an opinion about something that possibly might or might not happen. Either it is going to happen or it isn't going to happen, right?
Well, I can think of it in two different ways, but more overall, my assessment is that the project has very limited visibility, and therefore the opaque mesh would have, to some degree, limited impact to our overall assessment of the project.
And whatever impact that you believe that mesh fabric will have in terms of visibility of the fence line, is it your contention that the mesh mitigates or exacerbates the visibility of the fence?
I think it's going to be specific to the situation in which you're looking at the project where the mesh would be incorporated. Again, I think it is my understanding from the petitioner is that it was an attempt to look at potential mitigation that could or could not be implemented.
Well, I guess that's sort of the question I'm asking. Is this or is this not a mitigation? Or the other way to ask the question is this going to make it more visible? From whatever vantage point, would this black mesh fabric make it easier or harder to see the fence?
So as a general rule of thumb, black is actually a fairly suitable color to incorporate into the landscape. It disappears quite easily, where opposed to a white house or a white picket fence is a very apparent element in the landscape. So depending on the situation, I think you could have a different result. If it's put behind a buffer of vegetation where there's some very limited windows that you would prefer to further screen the actual elements within the project, I think that could be very successful. If it's an open landscape, an open view, and the mesh could actually make the fence more apparent.
Okay, so which is it here? You're talking in theoretical terms. We're talking about a project that you claim to have an opinion about, and I'm trying to find out on this project, Chelsea Solar, in the location that now it's been revamped at, is it going to make it more or less visible? And if that's a multi-part answer, then from what vantage points will it make it more visible, and from what vantage points will it make it less visible?
So my understanding from the petition is that views would be assessed post-construction. And where a mesh would make the project more visible, the mesh wouldn't be used. Where the mesh could be helpful in screening the project, it would be used. So therefore, it would make the project, it would help to mitigate the visual impact of the project if necessary.
So in other words, you don't know. Isn't that fair to say?
I would disagree with that.
Well, you haven't
If I could ask a
stated your
question.
answer.
You just so I'm clear on the potential mitigating value of the mesh screen. You indicated that it has a value in hiding a project inside if it's behind vegetation.
Correct.
But if it was in an open field, it wouldn't.
I think that my feeling is that it could increase the visibility of the fence, whereas increasing the visibility of the fence might not be an overall benefit to, because it might create actually more visibility than just
In an open field.
yes.
But in a wooded setting, it would look like it would help the project hide the shadows of the forest.
Correct. So, for an example, when there's a budding neighbor to the north that's separated by a fairly good amount of existing woods, but there are a few windows in those woods. So where they would have some very filtered views to the rear of the racks, of the racking systems, in that type of a situation, I would see it as being beneficial.
So, I'm picturing the layout of the project from north to south, and the proposed buffering around the edges. There's extensive buffering to the north, and extensive buffering on the highway side, so that's to the west, as well as there's trees, a pretty extensive layer of trees to the south. I guess it would be the western edge that may or may not benefit from the fence, the mesh.
That's correct. That would be my assumption.
I have to object to those questions on the record because they are leading and they are suggesting an answer to the witness. I don't know whether you can sustain or overrule an objection that you, on the question you asked, so I'm just putting it on the record. What color mesh would you suggest on the western portion where the wooded area is to mitigate?
I would suggest that any potential visibility be assessed after the project is constructed.
So in other words,
I'm sorry, can I finish my answer? Post-construction visits to review the effectiveness of mitigation is a common practice with projects in Vermont. It's a common requirement within PUC proceedings. That would be my recommendation.
Well, just because it's a common project, common practice doesn't mean it's a good practice. So.
It's also a commission rule too. Commission Rule 5.800 refers to the requirements for maintenance of, installation and maintenance of aesthetic mitigation projects. And it addresses, I would suggest that to the degree that it's relevant in this case, that the parties re-examine 5.800 because it is the standard now for the commission.
Right, but it doesn't eliminate the obligation on the part of the applicant to prove that this is a mitigating measure that is reasonable under the PUC analysis. Could you, Mr. Book, I'm sorry, I forgot how to say your name again.
Busher.
Busher. Could you turn to your simulation showing it's Appendix C, simulation number 2, sheet 3? If you could turn to that, please. And that's showing the east side.
Exhibit number C. Yeah, there it is. Which simulation? Simulation 2.
Simulation.
It's sheet 3.
Let me ask it this way. Do you have a picture of a simulation or any kind of photograph showing the fence and what it will look like?
Do we have a simulation that shows the proposed project fence? I just want to clarify the question.
Right. I believe from the east, where you can see the Bennington Monument in the distance to the left of center.
So simulation 2, northeastern property line, does illustrate the proposed fence on the eastern portion of the project.
So this is showing this black fence, if I'm looking at the same thing you are, that is where you see grass in the foreground, and then you see a black fence, and then there are trees to the left and right and beyond the fence.
That's correct.
Okay. So how is it that that black mesh fence is screened and not visible from that viewpoint?
Could you please clarify the question?
Would you agree with me that it's highly visible in this photograph?
Can you specify what you're referring to as highly visible?
Can you see it?
What are you asking? Are you asking about
the
the
last
mesh?
photo in simulation 2, in the series of photos just before the simulation 3 photo, in exhibit CSMB-5.
So I will clarify what my question back to you is. I am unsure if whether you're asking me is the fence visible, is the mesh visible? I'm not specifically understanding what you are asking me.
Do you think this is a fair and accurate representation of what the fence with the mesh on it will look like from the viewpoint in Exhibit 2, Sheet 3 of 3 in CS-MB-4? MS4, sorry.
If you refer to sheet 1 of simulation 2, there's 3 columns of text. Under the 3rd column, under sheet information, under sheet 3, it notes simulated conditions without mitigation. So the mesh has not been incorporated to the best of my understanding. These simulations are not personally created by me, but under my direction. To the best of my understanding, I can clarify that, and if I can have a second, that the mesh is not incorporated with the simulation.
If I may approach the witness, I just want to make sure we're looking at the same photograph, because I don't understand that answer. Would that be okay? So that I know.
Why don't you just hold it up?
Is that what you're
That's the
looking
same
at?
thing you're looking at, right?
That is correct.
Okay, and so what looks to me like a black fence that goes along here,
Yes.
is that with or without mesh?
That is without the specific opaque mesh. So it incorporates the black chain link fencing.
So it's a black chain link fence, not silver like we normally see around the school or something?
That's correct.
Okay, so this appears dark black to me. Do you agree?
I believe that this appears somewhat opaque. There are certain limitations into the modeling software that we use. It is pretty accurate, but there's some reasonable margin of error in how the software models that type of a finely textured material.
So what location are we viewing this picture from, this view from?
If you refer to sheet 1 of the simulation, there are specific viewpoint information coordinates provided, but generally this is from the northeastern property line of the orchard property.
Okay, so like Libby Harris would see this kind of view at her house?
This is, I believe, within the line of sight from Ms. Harris's property.
Okay, so in other words, we're gonna see a fence. Any trees gonna block that, be planted? Is she gonna be looking at this fence that's black and possibly will have even blacker mesh on it?
So, where this, and I'm trying to find the note. I thought that there was a note on this simulation. Give me 1 second. There is a note, we talk about the mitigation. So this does not incorporate the mitigation. If the mitigation was incorporated into the simulation, we'd be looking at a wall of vegetation, because we're standing literally immediately to the north of where the proposed mitigation on the plans issued by SE Group is located.
So these simulations are useless then because they don't show the plantings that are going to be there, so we really can't assess from this how much of the fence is going to be visible. Fair to say?
That is not fair to say. So when we do our analysis of a project, we first look at it without any mitigation, because without doing that type of analysis, we wouldn't properly understand what type of mitigation would be adequate or be effective to help screen the project.
Are you familiar with the town plan provision regarding screening mitigation in terms of earth tone colors?
I would prefer to see the text specifically that you're
In which town
mentioning.
plan are you referring
The one that applies to this case, the 2010 one? I understand that that's the one that was
to? Okay,
decided.
that's answer your question.
Could you refer to me to the exhibit?
Let me ask you this. Black, it's not an earth tone, you agree?
I couldn't say with specificity whether it is or is not considered an earth tone.
What is it? I thought you were a landscape architect.
I'm not a specialist in colors.
Have you ever Googled what earth tones are to find out?
My general impression is earth tones vary from a lighter to a darker tone that usually don't incorporate brighter pigments.
Lighter and darker tones of what color?
It could be brown, it could be gray.
But not black.
Black's a darker tone of gray.
There was some discussion between the petitioner and the neighbors regarding the idea that the black mesh could be changed to a different color, a green or earth tone color. Are you familiar with the different shades of mesh opaque material that is affixed to these fences?
I am not specifically knowledgeable in the precise colors, but I would imagine that you could get mesh in different colors.
So have you ever seen the black mesh in person?
I've witnessed solar scrim on the back of other projects, and that's typically a black mesh. And if I'm not mistaken, this might even be specifically solar scrim, which is a product sold to screen and also protect the rear of racking systems and ground installed solar projects.
Okay, so you're familiar with the black color of that product?
Yes.
Are you familiar with the green color of that product?
Not specifically for solar projects. I can think of a green mesh that, for instance, I've seen it on the side of chain link fences of tennis courts.
Like bright green or master's green. Is that what you're talking about?
A contra green, yeah.
Okay,
Forest
contra
green.
Okay. So these were samples that were given to the neighbors from the petitioner. Can you tell me what colors that they are?
The one on the right appears to be a very dark green, and the one on the left appears to be black.
And would you characterize either of these as earth tones? Well, I guess you don't know what earth tones are. Never mind, I'll withdraw that question. Okay. Would you agree with me that the proposed distribution lines will be a new element in the landscape?
There are portions of the proposed distribution line where there is not an existing distribution line.
So it's a new element in the landscape?
There are other distribution lines within the landscape. So there is portions of a distribution line that will be installed where there currently is not a distribution line.
And what about where there isn't currently a distribution line? Would that be a new element to the landscape or not?
I believe I just answered that.
You said where they already exist, it wouldn't be new.
I believe my answer was that there are portions of the line that will be installed where there is not an existing distribution line.
And that would be a new element in the landscape, yes or no?
Which landscape are you referring to? The landscape at which the new distribution line is going to be installed, or the overall landscape of the project site?
Well, let's go to page 10 of your orderly development, aesthetic and orderly development analysis report, because that's where that language exists. And we can figure out from you the answer to that question.
Sure.
And that's the August 9th, 2018 report.
referring to exhibit CSMB-2.
It's just after the CV. Let's see. What do you have for exhibit? Yeah, CS-BW 24. I'm sorry, I'm not sure what the number is. Just 1 minute.
I think it's dashed, I think it's CS, he only has two, it's MB2, is the report.
Is that going right after the resolution?
Yeah.
Oh, thank you. Yeah, the August 9th report. Could you say again what the number was?
CS MB2.
2. So page 10 of that report.
Is there a question?
Wondering if he's on page 10.
Yes, I am.
Okay,
Sorry.
do you talk on page 10 about the distribution lines being a new element or not in the landscape?
I think if you read the second paragraph on page 10, there is so travelers moving northbound would have visibility of the proposed distribution line and structures as they proceed along Willow Road. So there will be visibility of the new distribution line where there currently is not a distribution line.
Okay, so is that introducing a new element into the place where it is being erected?
Yes, you can consider it that.
And so would you consider that a new element in the landscape?
Sure.
Okay. You also indicated that the new poles will be substantially screened at some locations. Could you specify what locations will be screened and which ones will not be screened?
So there's sections of Willow Road that are immediately adjacent to Route 7 that has very minimal screening, so at that point, the poles will be visible, and as the road proceeds up a hill, there is existing vegetation that will screen the poles. Further to the east, there's more existing vegetation that will screen the poles when travelers going eastbound or westbound are approaching this area.
A question about what written standards apply to this project under the Creechy analysis, and I'd like to read you a statement from page 3 of Daniel Monk's pre-filed direct testimony that was dated June 22nd, 2018. I want to see if you agree with this statement. First, would you agree with me that the provisions that were contained in the 2010 town plan that is applicable to this proceeding, well, let me strike that. Did you review the 2015 town plan as well as the 2010 town plan?
No, I did not.
So the only town plan you've looked at is 2010?
That is correct.
Okay. Would you agree with me that in addition to the town plan, that the town's scenic resource inventory is applicable to this project?
Uncertain in what specific way you mean. Is it a valid document for this project?
Well,
Is that what
it's
you're
an
asking?
the exhibit for that inventory is CS-BW-24, which I understand is a document that you relied on?
Yeah, so it's a document that was adopted and reviewable, and we considered in our assessment of the project.
Okay. So when Mr. Monks testified in his pre-filed testimony that there were other municipal provisions that were applicable to this project, and he said
I'm
yes.
going to object, just the way this question is framed, it's being framed, and I'm thinking about if this were reviewed by a court on appeal, it's suggesting that this was testimony that was provided under oath, and that's not the case. This is a document that has been pre-filed and then withdrawn. So I think it's important to clarify that as these questions are being asked.
I think that's irrelevant. I'm asking him whether or not he agrees with someone's statement. It doesn't matter where it's from or whether it's under oath. If this gentleman agrees with this statement, he agrees with the statement. If he doesn't, he can explain why he doesn't.
Why is the statement relevant?
Because I want to make sure that we're on the same page in terms of what
Well, I
he...
mean, in terms of the foundation of the statement itself, what gives the statement any relevance to the inquiry? And it could be a statement from the newspaper. It could be a statement from the internet. I mean,
Sure.
What is this statement and what is its source? And you indicated it was Mr. Monk's pre-trial testimony from when? June of 2018. Is that correct?
Yep.
Which was withdrawn by the town.
Yeah, and you wouldn't let me put it into evidence, but then I said, but I'm going to read from this, and you said, okay.
Actually, we talked about the deposition testimony being available to be read from because it's a deposition, not the pre-filed testimony.
That's correct.
You held that I couldn't put this document in because I could not lay a foundation for it or nobody objected and all that other stuff. But that doesn't mean that I cannot ask a witness if he agrees with a statement in a document that people have seen, whether it is the newspaper. If somebody wants a copy of it, I'm more than happy to provide that.
What counsel is asking, however, is that the context of the statement be also relayed into the record. And now we've done it, so you can ask your question.
Okay, thank you. So you agree with that. Now, so in...
The witness did, I don't believe the witness agreed with anything.
Yes, he did. He said the town's scenic resource inventory is applicable to this project, and he
Okay.
acknowledged that his own exhibit, CSBW 24, is that inventory document, correct?
I don't believe that we specifically incorporated the document as part of our exhibit, but my understanding is it's an exhibit in the petitioners.
That you relied upon in deriving your opinions, right?
That is correct.
Okay. All right. You would agree with me that the proposed project is sited in the town's rural conservation district, correct?
Yes.
Would you agree that the rural conservation district is located in valley areas outside the urban growth area, which have retained their rural and open space character?
Yes.
Would you agree that the purpose of the rural conservation district is to preserve this distinct rural character while accommodating low-density residential development in a manner that avoids the need for public water supply and public sewer systems?
Not entirely.
What do you disagree with?
That is a partial statement of what the town plan reads as acceptable uses in that zone.
Okay, but the town plan indicates a purpose of the rural conservation district, does it not?
I would need to refresh myself by looking at that specific verbiage.
Sure, feel free.
Could you lead me to where that example is?
Plan exhibit number.
I believe if you're going to ask a witness to review a document, he should be provided with that document.
I thought he would have had the town plan as part of this material, sorry. I think the exhibit for the Bennington Town Plan is CS-BW-81. that would be Brad Wilson's documents.
If I may, I've got a copy of it here.
Sure, please. It wasn't me.
Here's
Just a moment. I guess on page 25 is where that section starts. If you caught up to passing in here. Okay, so on page 25, the very bottom line, the town plan says the purpose of the rural conservation districts is to preserve this distinct rural character while accommodating low-density residential development in a manner that avoids the need for public water supply and public sewer systems. Do you
I agree, that's what the town plan reads.
Okay, great. And in keeping with that purpose, specific design standards apply to new development in the rural conservation districts in recognition of the existence of a concentration of agricultural and forest lands, and to protect the extraordinary scenic resources such land and uses provide. Do you agree with me that it says that?
Are you talking about the third full paragraph down on page 26?
The final paragraph in the section, right above the agricultural district A.
I agree, that's what the town plan reads.
Okay. And development in this area, to continue with that paragraph, Development in this area cannot be sited in prominently visible locations on hillsides or ridges. Do you agree with me that it says that?
I agree, that is the language in the town plan.
And it says, it goes on to say, shall utilize earth tone colors and non-reflective materials on exterior surfaces of all structures, and must minimize clearing of natural vegetation. Do you agree with me?
I agree, that is what the language in the town plan says.
Okay. And that's pretty specific language, not some aspirational notion of some amorphous standard. Would you agree with me?
I think you put it into the context and what you're discussing.
Pardon me?
Depending on the context of what you are discussing.
Well, we're discussing this project.
There is language that is most definitely in the town plan that says all the things that you have said.
Okay, great. And you agree with me that's a specific statement about earth tones, very specific, right?
I would agree that the town plan has language that uses the word earth tones and shall utilize earth tone colors.
That's not the question. Can you answer the question, please?
That is my answer.
The question is, and that is a specific standard indicating earth tones, for one, right?
There is a statement that says shall utilize earth tone colors. When you start using the phrase specific standard, I go back to the Queechy analysis. And are you talking about a specific standard intended to protect the aesthetic, scenic, and natural beauty of the area? I would not agree that it meets that criteria.
A mandatory word shall, you would agree with me, means that it mandatorily has to be followed, correct?
There are previous decisions by the PUC that talk about how standards are specific to a project, to the project location, to how to preserve that. I've used past decisions. I have a long list of criteria that we evaluate when we're thinking about community standards intended to preserve the scenic quality and beauty. In my opinion, this does not meet those criteria.
Well, you're right. There are previous decisions by the Public Utility Commission, in fact, on this very case, isn't there?
I believe that I've not read the previous decision. I don't understand completely if that is a valid decision anymore. So I don't feel as if I can answer that question.
So you have never read the February 16th, 2016 decision of the Public Utility Commission on docket number 8302?
When the decision originally came out, we were asked to review portions of it. Employees in my office have read it. I've never read the decision in its entirety. When we were approached to do a secondary review of this project, one of the things that was expressed to us was we just want an unbiased third-party review. And therefore, I specifically restrained myself from looking at other testimony, exhibits, decisions that were part of this project.
But you're here testifying about other projects and standards from other projects, but not this very one that the Public Utility Commission has already discussed in relation to the town plan, the 2010 town plan, and whether or not there's a clear written community standard or not. Is that fair to say?
I'm not sure I fully understand the question. What I was explaining to you is the set of criteria that I use to evaluate whether something would be considered clearly written community standard in the context of the Queechy analysis.
Okay, then why don't you tell me whether you agree or disagree with this statement?
What are you referring to?
Well, can't I just ask him whether he agrees or disagrees with the
If
statement?
there's some context that can be placed with it, it would be helpful.
Well, why
So
don't we
that
ask him
understand for the record
first?
precisely what you're asking.
Why don't we ask him his answer first, and then if there's some...
No, I want you to tell me what you're reading from.
I'm reading
Using
from
the document.
page 50, that is the decision of the Public Utility Commission that rejected the hearing officer's recommendation with regard to aesthetics and orderly development and made specific findings after rejecting...
You're referring to the February 16th decision.
Yes, I am.
Chelsea Solar and docket 8302
I am.
on page...
50.
You have that
50.
case in front of you?
I did not.
Okay. Can you provide him with a copy of that case so he can look at it?
No.
Okay, well then read the question.
So this is what the Public Utility Commission said. We nonetheless find it appropriate to discuss it here, meaning the orderly development criteria, because the town plan language at issue is also applicable to section 248B1 criterion. Are you with me so far? The orderly development criterion.
Sure, do you want to just say it one more time so I have it down?
So it says that, I'll read the whole sentence so you have the whole context. While the specific language in the Bennington Town Plan was not reviewed as an issue under the orderly development criterion in this docket until after the hearing officer had issued his PFD, we nonetheless find it appropriate to discuss it here because the town plan language at issue is also applicable to the section 248B1 criterion, which states, quote, with respect to an in-state facility, will not unduly interfere with the orderly development of the region, with due consideration having been given to the recommendations of the municipal and regional planning commissions, the recommendations of the municipal legislative bodies, and the land conservation measures contained in the plan of any affected municipality. Okay? So do you agree with me so far that there's the orderly, that I just quoted from this, which talks about the orderly development criteria 248B1?
You're asking me to agree with you that that's a statement that was within that?
I'm asking, you are familiar with the 248B1 criterion on orderly development?
Yes, I am.
Okay, and that language sounds familiar to you?
Yes.
Okay. So, the PUC went on to say, for the reasons discussed below, the language of the Bennington Town Plan,
Apologies, I'm sorry.
let me start over. For the reasons discussed below, the language of the Bennington Town Plan causes us to reject proposed finding 3. We also reject proposed finding 32 because it does not accurately reflect the Bennington Town Plan's provisions regarding development in Bennington's rural conservation districts. Okay. So, I'm going to skip one paragraph on page 51, and after they talk about, this is what Chelsea argues, that it's consistent with the town plan, and the decision goes on to say, the town plan addresses all of the land area of the town. It recognizes the need for continued growth and promotes further concentrated development that may occur in the urban growth area. The town plan also includes rural areas designated for less development. Specifically, the town plan states that, quote, although development will occur outside brackets, the urban growth area, close brackets, it will be much less concentrated and shall not include new commercial uses because such uses are incompatible with the rural character of the area, period, close quote. So, that statement, do you agree with it or not?
I disagree with that.
How so? That's what the Public Utility Commission has already decided about this town plan in this case. How is it that you can quarrel with that conclusion?
There are town documents that specifically note they envision electrical facilities within the Rural Conservation District.
Okay.
And I would also note for the record that was in case 8302, which is a different case than this one, which is 17-5024-PUT. The projects are different and they're different cases.
I thought that they got in under the old town plan because this is just a vested rights theory case where it's the exact same application and they have the rights to go back under the original application because it's not a different project. While it may have been altered in some way, and that's why they were allowed to sneak in to the 2010 plan. While it may have a different docket number, I understood and I thought I've done a fairly good review of where this went and how it got decided and what the vested rights decision was by the PUC. I don't understand that statement. There are the whole
Are
point.
you asking a question of the witness?
No, I'm
You're making a
responding
speech.
to what you to your speech. I don't understand why you would say that as if somehow this is irrelevant information.
It's not
This is
irrelevant.
the law
It's not irrelevant at all.
This is law of the
If
case.
you have a question for the witness, I'm going to ask you to move on. If you want to brief the law of the case, as we discussed earlier, you can do so in your brief. This is
I'm
not
trying
the
to see.
appropriate setting.
I'm trying to see if this gentleman, as an
Okay, ask him a
aesthetic
question.
expert, agrees or disagrees
And he's
with
answered your
what the
question, and he says he disagrees with
Okay,
your
so he
interpretation.
disagrees with the PUC. But I don't understand why the hearing officer is intervening.
Because
and
you're calling it this case.
it is this case.
No, that's 8302, but this is 17-5024-PET.
I am putting an objection on the record that I believe that you are biased, that your decision before was overturned by the PUC, and you are being obstructionist to the flow of evidence in this case. You have already called my clients names and said they're not, in fact, naive. What do you mean they're not naive? What's going on here is really troubling. And I want that on the record because I do not believe that my clients are being treated fairly, and to suggest somehow that this is a different case when that's the whole reason why they got in under the 2010 plan, in my opinion, is erroneous. But let me continue. Do you agree with this statement by the PUC on page 51, second full paragraph, first sentence? The town plan addresses all of the land area of the town, yes or no? Page 51, second full paragraph, first sentence. The town plan addresses all of the land area of the town, yes or no?
I would agree that the town plan addresses all of the land area within the town.
Do you agree with this statement in the next sentence? It recognizes the need for continued growth and promotes further concentrated development that may occur in the urban growth area, yes or no?
Are you asking me if I agree that's the verbiage in the town plan?
I'm asking you if you agree with the PUC's opinion that says, quote, it recognizes the need for continued growth and promotes further concentrated development that may occur in the urban growth area, yes or no?
So, as far as...
It's a yes or no question. Either you agree or you disagree.
I cannot agree without further explanation.
Okay, let's move on. Do you agree with this sentence, the next one? The town plan also includes rural areas designated for less development, yes or no?
Yes.
Do you agree that In the next sentence, specifically, the town plan states that, quote, although development will occur outside the urban growth area, it will be much less concentrated and shall not include new commercial uses because such uses are incompatible with the rural character of the area, unquote.
If that's verbiage in the town plan, I would prefer to have that pointed out to me.
Okay, it looks like it's at page 16.
Could you point out where on page 16?
It's at the very top of the page. First sentence. Page 16, Land Use Chapter 3.
I'm going to read some context just to let me understand where in the town plan this is, and that will help me answer your question. Could you now repeat the question?
Sure. Do you agree with this statement? Specifically, the town plan states that, quote, although development will occur outside, bracket, the urban growth area, close bracket, it will be much less concentrated and shall not include new commercial uses because such uses are incompatible with the rural character of the area.
I believe that is language that is stated within the town plan and the overall opening to Chapter 3 of land use.
Yes, would have been sufficient. Okay, so let's try to move a little quicker. Do you agree with this statement on page 52 of the PUC's decision? Bennington's rural conservation districts are located in valley areas outside the urban growth area and have retained their rural and open space character.
There are most definitely locations within the RC district that I would argue do not retain their rural character.
So you disagree with that statement of the PUC, is that fair to say?
I would disagree that the overall district is completely intact as represented in that statement.
Do you agree with the next sentence the PUC wrote? The purpose of the rural conservation districts is to preserve traditional rural and agricultural uses while accommodating low-density residential development.
There are other uses within town documentation that are acceptable per the town regs.
Can you answer the question? The purpose of the rural conservation district is to preserve traditional rural and agricultural uses while accommodating low-density residential development.
Is that a statement in the town plan?
Do you or do you not agree with that statement? You're the expert. you tell me, is that something that the town plan says? Because that's what the PUC says the town plan says. You disagree with them?
I'm going to object. This is almost badgering the witness.
And I believe the question has been asked and answered. She asked the question, do you agree with this statement? He said no.
If he had said no, I would have moved on. He didn't say no. I can't get a straight answer from this witness.
If I'm wrong, but I believe I have the right to explain my answers.
But you're not giving an answer.
What's your answer, Vincent?
My answer is that my review of town documentations include additional uses beyond that description for this district.
So do you disagree with the commission's characterization in his decision?
I do disagree.
You do? Do you agree or disagree with this statement? For example, the town plan states that, quote, agriculture, forestry, very low density single-family residential development, and certain limited uses that are suitable in rural areas are permitted. And that is on page 26. First full paragraph on the page.
Yes.
Okay. Do you agree with this statement? The interchange at the junction of US Route 7 and Vermont Route 279 serves as the southwest corner of the Rural Conservation District in which the project is proposed.
Yes.
Do you agree that the area immediately to the west of Route 7 is in an industrial district?
I would need to review the town land use plan.
Do you agree then that the area immediately to the south of the interchange is part of a mixed residential district?
If you would let me look at the town land use plan, I could answer these questions. Without having that plan in front of me, I cannot answer these questions precisely.
Okay, that's fair.
Thank you.
So the witness has just been handed something.
Now, do you want to state what it is? It's my understanding it's page 3, figure 3-2 on the 2010 town plan. Is that what it is?
Yeah, and it specifically exhibit MACC-ML5.
So this is an element of the town plan.
Yeah, it's just a little page that has the map
Okay.
on it.
We have 3-2 on page 31.
So, is the area to the west of Route 7 industrial district?
Also incorporating part of the exchange with Route 7 and 279. For a limited portion, it's industrial west of Route 7.
And then the area immediately to the south of the interchange is part of the mixed residential district?
Yes, that is accurate.
And the areas east of the project site are in rural residential, rural conservation, and agricultural districts?
Yes.
The interchange highway complex thus serves as a boundary between developed urban and industrial areas in the western, central, and southern portions of Bennington, and minimally developed rural and agricultural areas in northeastern Bennington.
There is clearly visible development further northeast of the proposed project site. The project is located at what you characterized as the southwest corner of that specific block of the Arcon district.
We're referencing back to page 26 for this question in the town plan. the town plan makes the following design standard applicable to any new development in the rural conservation districts. And this is the quote, specific design standards shall apply to new development in the rural conservation districts in recognition of the existence of a concentration of agricultural and forest lands, and to protect the extraordinary scenic resources such lands and uses provide.
That is the language within the town plan.
And it goes on to say, on page 26, any use in the rural conservation district, including single-family dwellings, shall require approval under those regulatory guidelines. You with me?
I am following you, yes.
It says that, right?
It does say that.
And then development in this area cannot be sited in prominently visible locations on hillsides or ridgelines.
That is the language.
Shall utilize earth tone colors and non-reflective materials on exterior surfaces of all structures,
Yes.
and must minimize clearing of natural vegetation.
Yes.
Okay. Do you agree or disagree with this next statement by the PUC? This land conservation measure is made specifically applicable to the project site by the town of Bennington's land use plan. And if you look at page 31, that may give you that reference. 31 is the map. Want me to read that again?
I'm sorry. Yes.
So they decided the land conservation measure is made specifically applicable to the project site by the town of Bennington's land use plan. You know, what we're talking about is what we just read, and you agreed that that's what the town plan said about prominent visible locations on hillsides, ridge lines, utilizing earth tone colors, non-reflective materials. That paragraph, that land conservation measure is made specifically applicable to this site by the town of Bennington's land use plan. Do you agree with that?
That is a paragraph in the land use, in the town plan specific to the rural conservation district.
So you agree that they're specifically applicable to this project?
You need to look at this project and how it is, the context in which you're looking at it. So did we look at these components as part of this project? Yes, we did.
Because they are specifically applicable to the project.
Because it's in the Archon district.
Right. And this project's in the Archon district.
That's correct.
Okay, I think we're on the same page. This is what they said next. While Chelsea has taken steps to limit the visibility of the project on the hillside where it is proposed to be located, the clearing of 10.6 acres of existing vegetation runs directly afoul of this provision in the town plan and its vision for orderly future development. Now, this is the first version of this project,
I
where the clearing was 10.6 acres. Do you agree with that statement about the 10.6 acres?
I didn't assess the original project.
Okay, all right. How many acres is being cleared in this project?
9 point, I don't have the numbers directly in front of me.
9.64?
I believe that's what was stated earlier today.
Okay, so we're talking about less than 1 acre difference
Okay.
between this project and at least what the PUC understood the last project was cleared. Because 10.6 minus 9.64 is less than 1, correct?
Thank you.
Do you believe that the clearing of 9.64 acres of existing vegetation runs directly afoul of the provision of the town plan we've been discussing?
I do not.
The PUC, we're almost, we're closing in on it, but the PUC said next, in its reply brief, Chelsea argues that, quote, the only testimony in this docket concerning the orderly development of the region aesthetics, wind, and noise supports the conclusion that the petitioner satisfies the requirements of 30 VSA section 248B1 and B5. That was Chelsea's argument that the PUC was describing. They go on to say, in support of this argument, Chelsea cites the testimony of its aesthetics expert. Then they say, upon review, we find this testimony to be an inaccurate description of the town plan. Do you have an opinion about that statement?
You'd have to restate that.
Okay. So in the reply brief, Chelsea argued the only testimony in that docket concerning orderly development of the region, aesthetics, wind, and noise, supports the conclusion that the petitioner had satisfied the requirements of 248B1 and B5. And then they, in support of that notion, they said, all right, that's because our expert says so. But the PUC said, upon review, we find this testimony to be an inaccurate description of the town plan. Do you disagree with that?
I don't believe that provides me with enough context to make
I'm going to object. He doesn't have the testimony that's even being referenced. How could he give an opinion on it?
I'll move on. On page 54, the PUC in the second paragraph says, rather, we find, based on our review of the town plan, that the project will unduly interfere with the orderly development of the region because the town plan articulates specific land conservation measures applicable to the project site that would be violated if the project were to be constructed. So, you have agreed that there are specific land conservation measures applicable to this project, and we went through those.
I agree that there is specific language
Yep.
in the town plan.
Do you believe that were applicable? I'm sorry, let me strike that. So, yes, you agreed that was in the town plan, but you also agreed that it was these conservation measures were applicable to this project, correct?
I'm sorry, could you repeat that?
The fact that these articulated specific land conservation measures that exist in the town plan, that you've agreed that's the language. But my question is, you are agreeing that they are applicable to this project?
I think you misrepresented what I said. I didn't agree that they were specific land conservation measures.
So you disagree with the PUC that, even though you agree that the language exists, you don't think those are specific land conservation measures?
I do not.
And do you believe, so you don't believe they apply to this project because you don't believe they exist? Is that fair to say?
I'm saying that I do not believe that that would constitute a measure that would be considered land conservation.
Okay, so you see no violation of the provisions that we've been talking about, the specific provisions that you apparently disagree are specific provisions, but you don't think they apply because you don't even think they're specific provisions?
I don't think that they apply specific land conservation provisions.
Okay, do you agree with the statement on page 56 of the order and decision that in order for a provision to be considered a clear written community standard, it must be, quote, intended to preserve the aesthetics or scenic beauty of the area, close quote, where the proposed project would be located and must apply to specific resources in the proposed project area?
Yes.
Do you agree with this statement? A clear written community standard must be more than simply, quote, general in nature, unquote, and do more than seek to, quote, promote good stewardship of scenic resources without identifying specific actionable standards.
I agree.
Okay. Do you agree with this in the next paragraph? The town plan language for the Rural Conservation District creates 4 specific requirements. And the first one of which is only limited residential development is permitted. And that has a citation to page 16.
I disagree that ultimately, if you review all the town documentation, that only limited residential development is the only use allowed in the rural
So
conservation.
you're saying the commission got it wrong?
Yes.
How about the second requirement? No development may be sited in prominently visible locations on hillsides or ridges. And they have a reference to page 26 on that.
So are you asking me if that's language within the town plan?
So their statement is the town plan language for the Rural Conservation District creates 4 specific requirements.
Okay.
So the first one was only limited residential developments permitted, and you disagree with that. The second one is no development may be sited in prominently visible locations on hillsides or ridges. Do you agree or disagree?
I agree that that is one of the criteria in town plan, yes.
Okay. And the third one is any development must utilize earth tone colors and non-reflective materials on exterior surfaces of all structures.
Yes.
And number 4 is any development must minimize the clearing of natural vegetation.
Yes.
Thank you. So, they go on to say the project violates, and this is the prior version, violates 3 of these 4 specific requirements in the town plan for development in the Rural Conservation District. First, Chelsea Solar is not proposing a limited residential development.
I agree that it is not a limited residential development.
Do you think then, okay, but that violates the first standard that you disagree with, correct?
When I did my review of orderly development, I did a comprehensive review of this district and different documents within the town's purview that orient how development should occur. And I disagree that limited residential development is the only allowed use in this district.
Okay. Then they go on to that second criteria. Second, while Chelsea has developed an extensive visual screening plan, the project would remain visible on a hillside above the Vermont Welcome Center. So
I disagree.
you disagree with relation to this project.
Disagree that the project would be visible on the hillside from the Vermont Welcome Center.
Okay.
Is that what it says? From the Welcome Center or above the Welcome Center?
Above the Welcome,
So
Vermont
it doesn't
Welcome
say
Center.
from the Welcome Center.
If I misspoke, I apologize.
So do you agree that it would be visible from locations, from anywhere, at a site above the Welcome Center?
There are locations where the project will have visibility in a context that the Welcome Center will also be visible. These locations are typically distant locations.
So you disagree with the visibility part of that, is that right?
I'm not sure I understand.
Because the statement was, while Chelsea has developed an extensive visual screening plan, the project would remain visible on a hillside above the Vermont Welcome Center. So you say...
Based on my review, there will be some very limited locations where the project will be visible in a view context in which you would also see the Vermont Welcome Center.
Do you disagree with the statement it's on a hillside?
There is no clear definition of a hillside in the town plan.
So if there's no clear definition in the definition section of the town plan, how do we know what a hillside is? What do you do to figure that out?
There are different degrees. Obviously, most everything could be considered a hill that has any type of a slope to it. So to make that as a blanket statement doesn't provide enough specificity to really understand what the town's intention was from that standard. My personal guess would be that it would be on higher elevations. This is a fairly low elevation where the site is. It's a fairly modest slope. There's Bald Mountain. I was involved with the Belco, the Bennington substation, in which that was definitely a concern, and we worked well with the town to site that project, which I believe is also in the Rural Conservation District.
Okay, we're talking about hillsides. You mentioned the slope.
I was using that as an example of a hillside.
Okay. So, well, you could say Mount Mansfield's a hillside too, but, so you're saying you disagree with the PUC that this site is on a hillside or not?
I would disagree that this is on a prominent hillside.
I asked hillside. We talked about visibility a minute ago. I'm talking about hillside. You referenced slope. What's the slope? You said it was modest. What's the number?
Again, I'm going to restate that there's no clear definition of a hillside.
I understand, but what's the slope? That's the question then.
I'm going to object. I think he's asked and answered.
He said moderate slope, and he has not answered that question. He has diverted to try
Do
to
you have
answer
data
something else.
that you're aware of in the case that there's a rise in elevation?
Yes, there is.
And do you know what the number of, what the slope number is? What percentage?
I do not remember offhand. We did look at that at one point.
And then let's go on to the third one. The project calls for clear cutting of 10.6 acres of a densely forested and undeveloped 27-acre parcel. Do you agree with the statement, other than the number of acres, that it's densely forested and undeveloped 27-acre parcel?
Could you please repeat?
Sure. Okay. So third, the project calls for clear cutting. You agree it's being clear cut?
Yes.
Okay. In this case, it was 10.6 acres.
Yes.
So we're talking about 9.64 this time. So let's skip over. So project calls for clear cutting of a densely forested and undeveloped 27-acre parcel. Do you agree with that?
Try more.
I'm sorry.
So I'm agreeing that the project is requiring the removal of vegetation off of 9.64 acres within the forested portion of the project site.
So it's being clear cut, right?
I'm agreeing that there is 9.64 acres is being removed, yes.
It's being clear cut, or not?
It is being removed, yes.
The question is it being clear cut, yes or no?
Yes.
Thank you. This doesn't have to be that difficult.
And just to note that the schedule for Mr. Busher was for 1 hour, which began at 1 o'clock. It's now 2:20. So I'm going to ask you, if you can, to conclude as soon as you can.
I'll shorten up Mr. Kane's cross to make up for it, if you don't mind.
Okay. How long do you think you're going to be
For Mr. Kane?
for Mr. Busher?
Oh, maybe another 10 minutes, maybe. Thank you. So you disagree with the PUC on page 58 that with their finding that the town plan language is specific in nature, is specifically applicable to the project site, and seeks to conserve scenic resources by identifying specific actionable requirements, and thus constitutes a clear written community standard. Do you agree or disagree?
There was a lot of components to that. I'm not familiar, I've not studied that decision. I feel as if you're asking me these questions without my ability to fully understand the context from where they're coming from.
Does the 2010 town plan language constitute a clear written community standard or not?
In respect to acuity analysis?
Yep,
No.
it does not. Okay.
I should actually qualify, I should say no in the respect that the project does not violate a clear standard.
Okay, so that's really different. So are you saying that there is or is not a clear written community standard contained in the 2010 town plan with regard to the, what do we call it, Rural Conservation District?
There are components of the town plan that lay out generalized ideas of what the development should be. This, you're referring to.
I have to interrupt,
you're-
please. I'll withdraw the question, so please don't respond. The question is there or is there not a clear written community standard that is applicable to this case that is contained in the 2010 town plan with regard to the Rural Conservation District? Yes or no?
Yes.
Thank you. But you believe that applying that clear written community standard from the 2010 town plan to this project results in a finding that there's no undue adverse impact, correct?
Yes.
Okay, great. Can I just have 1 moment to confirm?
You described for the record which will be
I certainly.
This is my report testimony. Okay, student number. Student, yeah, MACC-ML1, page 6 of 13.
Your Honor, for the record, I have this marked as Exhibit Cross 2. but it is just a blow-up photograph of exhibit MACC-ML1, which is Maru Leon's testimony, well, the exhibits that were with her testimony. It's page 6 of 13 of that exhibit. So
Okay, so I'm looking at her exhibit.
it's the 6th page.
And what you're holding up is a approximately 14 by 30 blow-up of the section of the MACC-ML-1 on page 6 is referred to as a section of the full-size panorama showing Chelsea Solar Project on the south of Pineapple Hill. Okay.
So what I wanted to ask you was,
You just take it from the line.
so this was a photograph that was taken from the Bennington Battle Monument, from the upper window. And I wanted to know, in your opinion, is this a fair and accurate representation of the view from that location?
I do not believe that is a fair and accurate representation of the view from that location.
Okay, why not? Well, first, have you been up the Battle Monument?
I have.
Have you taken any pictures from there?
I have.
And then tell us why you don't think this is a fair and accurate representation.
If you refer to our exhibit CS-MB4,
But just tell me, you don't need to look at exhibits, just explain. Why don't you think?
because a picture is worth a million words, and we have a picture that shows the view from the Bennington Battle Monument, which is an accurate representation of how visitors to the monument would experience the view towards the project.
So you disagree, you think, so, have you done any photo simulations from the Bennington Battle Monument?
For this project, no.
And in terms of, so then I would assume, since you folks had a chance to look at cross exhibit 4, which is a superimposed, the 2 solar arrays.
I'm going to object to this exhibit. I said that I would object.
Yeah, I'm not sure what I'm looking at either, it hasn't been described.
That's what I'm trying to do.
Well, you're
Okay,
not.
before you ask a question, introduce what you're showing us.
Okay, I am showing you the exact same photograph we just looked at with solar arrays superimposed from Google
But
Earth.
there are 3 pictures on that.
Right. Solar array, and this is the Google Earth document.
Yeah.
Okay, so what I'm looking at from the bench
That's 3
is
photographs.
is the same size white backboard with a 1 in the corner, and I think there's a 1 in the corner.
Correct.
And in that picture, in the upper left-hand corner, there is what appears to be the same picture with some addition to it. In the upper right-hand corner, I don't know what I'm seeing there. And in the bottom center is what looks like the same picture with, from this distance, appears to be the project as a photo simulation.
And the basis of my objection is that these photographs have not been authenticated.
I'm not trying to introduce this into evidence. I'm trying to ask a question.
You're asking
It's
a
a demonstrative aid at this point. It is
Okay, so
not
you're not going to
demonstrative.
turn it into evidence.
I think
I may not. Right now, I'm not offering it.
the question, though, is you're asking my witness to give an opinion
I
about.
haven't asked him anything. No one's let me ask a question yet.
I am concerned about even using these because I don't think they're representative of the views. There's been no
Maybe you can say so.
authentication.
Maybe you
Okay.
can say so, okay? I
Well,
wasn't even
how
gonna
are-
ask
how
him
are
that.
these simulations, we don't really know how the panoramic view was created. We don't know how the panoramic view simulations were created.
We
The
will.
exhibits in this record that reflect simulations discuss how those things occurred
Yep.
and describe it.
Yep.
I just simply want to have the same kind of information related to your pictures.
And I will object because the parties that are being represented had an opportunity last Friday to file these.
Can I
Please let her finish her objection.
To authenticate these, under the rules, there has to be personal knowledge, under Rule 602.
I'm not offering it to be.
So what, to
You-
what
you
purpose,
haven't-
to what
then
purpose
it's
do
not
you?
relevant.
If you would just let me ask the question,
It's
then
not-
you can object if
You're-
you want.
You're tying the question to a document that's neither relevant, its probative value is outweighed by the prejudice and the
There's no
misimpression.
prejudice. This is a professional gentleman who does this every day
This
of the
record,
year.
this question and answer based on a document that you may not enter, or may enter, is creating a prejudicial record because
Okay,
it's a
if I
misrepresentation.
could hear what your question is,
Thank you.
then you can offer an objection.
So,
Now that I have some understanding as to what you're showing us.
okay, so the bottom picture is this photograph. I understand you don't think it's a fair and accurate representation, but my question is this. So superimposed on this bottom one are some solar panels, solar arrays. Why didn't you do photo simulations similar to something like this, where you actually inserted the an actual representation of the solar arrays to the appropriate scale from the Bennington Battle Monument? Whether you think this is good, bad, or indifferent, it is just representative of something that a novice layperson did. Why didn't you, knowing how many hundreds of thousands of people have visited the Bennington Battle Monument, why didn't you think that that view was important enough to create a photo simulation so that
Okay.
we could see what it looks like from there?
So, the general practice for creating photo simulations is that you want to go to locations where you're anticipating the most critical impacts of the project are going to be experienced. We provided a simulation from the Welcome Center because it is a very close context. The project's in close proximity. We wanted to understand what that impact would be. We provided a simulation from the northwestern property line because of the context, not because of the frequency of usership, but because we knew that there was a sensitivity from the nearby neighbors. And we also provided a simulation from of the distribution line, because that is a road that is commonly experienced on a daily use. If you go up the Bennington Battle Monument, the view is really oriented in 4 different directions. And the reason for that is because it's a stone monument, and where you get views from the monument are directed through these very long, narrow openings. If you refer to our photo catalog on page,
This is exhibit.
this is exhibit CS MD4. If you go to page B45, a portrait view standing on the observation deck of the monument, looking obliquely through the opening in which people are viewing the surrounding landscape from the monument.
So let me ask you then, how many people
Sorry, I
did you?
haven't finished my
Well,
explanation.
that's fine.
I would
think we're
prefer
done.
that.
I have a question. So you object, you say you don't think that the picture that is in MACC-1 on page 6 is an accurate piece of representation. Why don't you think so?
Well, to really analyze that, I would want to know if it is represented at a 50mm focal length.
You don't know how it was created.
I don't know how it was created. I don't know the angle of view. My understanding is that the camera location was actually extended outside of the window.
So let me ask you, how many people go to the Bennington Battle Monument and stick their camera out the window and take a picture? Do you have any idea?
I don't have that information.
Well, then how is it that you can give a conclusion that this is not a fair and accurate view if you don't know what the view looks like when somebody holds their camera out the window and takes a photograph?
Because that's
You would-
not-
You
because
would
what-
agree with me, would you not, that, so in other words, because you didn't do that, then you don't know whether it's a fair and accurate representation if the camera was being held out of the battle monument, correct?
If I could ask a question, please. I'm looking at the photographic, at the page B46 photo that you're referring to, the one that is in your, is it 46?
E45.
E45. How was that photo taken?
That photo was taken, so there's a long, narrow opening, and that photo is taken from the edge of the opening, looking sort of crosswise across it.
How long, how big is that opening? How wide is it? Yeah, well,
Foot and a half?
foot and a half is the opening from left to right.
Yeah, so you're,
And the density of the window space of the wall.
a couple of feet at least.
So this is the, so this photo was taken standing in front of that hole and looking out in a place that, at that location.
Yeah, this is a very narrow sliver where if you would move to the left, that, you know, the view would become much wider and be oriented away from the project.
Do you have an opinion as to how the photo that shows the panoramic view was created?
My guess is that the camera was held.
Objection, he's guessing, he can't opine about something like that.
How was that? Well, I'll ask, we'll
I haven't
observe
had
that.
a chance to put my client on for problems.
Yeah.
It's not how people experience the view.
How do you
So-
know that? How many people have you talked to? Back that statement up, that's not how people, how many times have you been to the Battle Monument? And how many times have you actually observed somebody taking a picture from the Bennington Battle Monument?
I couldn't answer that question.
And do you know about the magnets that they sell in the gift shop that have this panoramic view? And all of the people that purchase that, and the calendars,
What
and
I
the
can
books,
tell you
and the pictures,
is
and
that-
the
Just a
framed
second, let me
prints.
ask her question.
And the framed prints, do you have any idea how many of the 28 to 35,000 people per year purchase those products with this view from the Bennington Battle Monument?
My assessment is based
Do you
on-
have any
Yeah,
information about that?
If
That
you're-
is the
I object-
question.
I object, you're interrupting
He's not
him.
answering the question.
You are stopping me from speaking before I can get 3 words out of my mouth.
Okay,
How-
okay. I want to take a 10-minute break. I will come back at 10 minutes before the hour. And then at that point, we have 5 more minutes with Mr. Bush.
You would answer, thank you. I'm good on the picture.
And before I should maybe go back on the record. Okay, it's now 8 minutes before 3. Back on the record. Mr. Busher is on the stand. You're still under oath, sir. Timothy, do you have a question for the witness?
Before I go there, Your Honor, I wanted to just put on the record that I have an objection to register, and that is, during the break, the witness was discussing his testimony with counsel and petitioner. I asked them to please stop doing that because this is not a take-home exam. He should not be coached during the hearing. He's in the middle of his cross-examination and ought not to be discussing with counsel what his answers should be going forward. So I asked that it stop. It did, so I'm glad about that, but it was concerning, and I was told that's how we do it here. I've never heard of that before, in the middle of someone's cross-examination being able to be coached by a lawyer, but, so I have an objection that that happened.
And I will agree that we were discussing his testimony with the witness. We were also discussing the cross-examination and the fact that he has not been able to get answers into the record. It is common practice when there are, in these proceedings, it's common practice when there are breaks that the witness confers with counsel. It happens in virtually every case, contested case I work on.
Okay, I'm going to note the objection
Thank you.
And we did.
and a response.
And a response, thank you.
You have a question?
Very briefly, just to finish up. Would you be able to turn to page 41 of the town plan? That's chapter 4, Natural, Scenic, and Historical Resources.
EW 81.
Yes.
The photograph that appears on that scenic resource page, which has a caption under it, it says Bennington's natural and built environment combined to create a truly unique sense of place with outstanding scenic qualities. You agree it says that underneath the photograph?
I agree.
Now, I'd like you to take a look at the surrebuttal testimony of Maru Leon on behalf of the Mount Anthony Country Club. It was submitted September 14th, 2018.
Do you have a copy for the witness?
I do. And that is exhibit MACC-ML-1.
That's the number in the file? The 300? Okay.
So if you can turn to the second page of the exhibit MACC-ML-1, just turn the page to the second page of that
Yes.
exhibit. And that photograph, these are the photographer's images of Bennington that are sold, and there's been the surrebuttal pre-filed testimony indicated such. And this was a photographer named Ann Smith who sells this image. And it's this is the photo magnet image showing the view from Southern Vermont College Orchard House, which is sold at the Bennington Battle Monument Gift Shop and some other places in Bennington. Would you compare this photograph on page 2 by Ann Smith with the photograph on page 41 of the scenic resource section, and tell me, in your opinion, if you believe that this is from a similar vantage point as the photograph in the town plan?
It's depicting the approximate same portion of stone wall. The angle of view is slightly different between the two images,
Yeah.
but generally it's representing the same view.
Okay. And you would you, so you did not, for example, take the photograph from the scenic resource section of the town plan and superimpose the solar array in that or some similar view from the Southern Vermont College area, did you?
We did not provide a photo simulation from Southern Vermont College
Or from Mount Anthony Country Club?
or from Mount Anthony Country Club.
So if you turn the page of the exhibit from Maru Leon, if you turn to page 5 of that exhibit, 5 of 13, and those are Greg Nesbitt, who is a photographer, and he has photographs from Mount Anthony Country Club. So this indicates views where there is an arrow depicting approximately the location of the solar array. Would you agree with me?
Generally, yes.
Okay. You didn't do any photo simulations from the Mount Anthony Country Club?
We did not provide any simulations from Mount Anthony Country Club.
So would you agree with me that it looks, at least from these vantage points, that this is an area that the solar array project, if 9.64 acres was clear cut, does appear that it would be visible from the Mount Anthony Country Club, does it not?
I believe if you refer to our report, we note that there will be portions from Mount Anthony Country Club where portions of the project will be visible.
So if that's the case, then why didn't you do any photo simulations from the locations where you're pretty darn sure that it was going to be visible from? So that we could see what it's going to look like.
We did simulations from areas where we felt they had the most sensitivity.
Okay, but we have interveners here, and Mount Anthony Country Club is here at this hearing, has put in evidence, photographic views, has repeatedly, indicated that there are going to be undue adverse impacts. Yet you didn't think it was important enough, given all the people that play golf and go and have events, weddings, and they have a very robust restaurant. Many people go there. You didn't think that that was important enough, given the public nature of that area and how many people of the public, in-state, out-of-state, visitors, etc., would be coming to visit? And and you just thought it wasn't important enough?
We most certainly felt that evaluating the project from all areas where there would be visibility, publicly accessible, was important, and we did do that assessment.
But you didn't do Mount Anthony. Right? You already said yes, so correct?
You're asking if we prepared a photo simulation or not.
Right.
It's not saying that we didn't assess the project.
Okay, we're wordsmithing. So, didn't think it was important enough, given the many visitors and people that play at the country club and use that for special events, didn't think that that large number of people from the public who would see this from various holes and vantage points on Mount Anthony Country Club, you chose not to create photo simulations so that we could see what it would look like from that vantage point. Fair to say?
I believe I answered that. We prepare photo simulations.
You
from
didn't
areas-
do it.
I'm gonna tell you to let the witness answer this question as
sorry.
asked.
Beg your pardon.
We evaluate areas that have the most sensitivity. Obviously, the Vermont Bennington Welcome Center has a substantially greater importance than a private facility in which you need to pay access to. So we chose the locations where we felt had the greatest sensitivity, and those are the locations we provided simulations from.
So if you have to pay to play golf, your views don't matter? Is that
No,
what
I'm
you're saying?
saying that it restricts the amount of usership that is at that location compared to a location such as the Vermont Welcome Center, which has a more statewide significance.
Do you have any idea how many people go to the restaurant at the Mount Anthony Country Club and what a robust business that is?
I do not.
Oh, okay. And you made a judgment with non-complete information on
I
it.
think
What about Southern Vermont College?
we,
Awful lot of people there. Didn't make any photo sims from that location, right?
So we looked at the project.
Yes or no? Did you make
Are there facts
photos?
and evidence to articulate the numbers that you're referring to at those locations?
Pardon me?
Are there facts and evidence that show the numbers that you're referring to at those locations as opposed to the numbers at the Walker site?
I certainly can put that evidence on when I call my witnesses,
And I will object.
if
because
that's an
it's
interest.
untruthful.
After all, we need to hide the truth, don't we? I know you will object, unfortunately.
For the record, I'm not objecting to hide the truth. We've had an orderly process where testimony was pre-filed, and I've been very patient, but I will object to the constant testimonial statements that are being provided by Ms. Dingledine, and also to her consistently cutting off the witness. It's very difficult for a witness to answer questions under cross as it is, but she's badgering him and cutting him off, and the record is not going to reflect his opinions as a result.
He's not answering the question, Your Honor.
He's
And
not
when I
answering
say-
the
Okay,
question.
this isn't, I hear this, it's understood. You need to make sure you give me the opportunity to answer the question, which you have not been doing, and you need to answer the questions as they're asked, not as you wish they were asked.
Southern Vermont College, are you aware that that's a National Historic Site?
Yes.
You did not do any photo simulations from that property, did you?
We did not.
That's all I have, Your Honor.
Thank you. Mr. Busher, can you please turn to your report, which is Exhibit MB2 at page 26? It's your order of development discussion.
Yes.
And you don't need to read it out loud, but you recite there the section 248B1 standard. Does this standard require that there be conformance with a town plan or town plan provisions?
No.
And you've worked under Act 250, is that correct?
I'm sorry, I didn't hear that.
Have you worked on projects that go through the Act 250 review process?
I have.
And are you aware of whether or not a conformance standard is required under the Act 250 criteria?
Objection, relevance.
I'll withdraw that. Let's go to page 28. The second paragraph, it's actually a quote from page 26 of the town plan, which is exhibit CSBW-81. Do you see that?
Yes.
Okay. So I believe there was a lot of discussion about standards in your cross-examination, and I want to ask you about the last sentence in the quote, which I believe was already read into the record. Is it your opinion that the project will it be cited in a prominently visible location?
I do not believe the project is being cited in a prominently visible location.
And is it your opinion that the project, and let me ask this, is it your opinion that this standard or statement cannot be cited in a prominently visible location on hillsides? Is it your opinion that that's a clear community standard?
I do not believe that's a clear community standard.
And let's go to the next one, that it shall utilize earth tone colors and non-reflective materials. Do you believe that that's a clear community standard?
No, I do not.
And that it must minimize clearing on natural vegetation. Do you believe that's a clear community standard?
No.
Do you have, okay. And do you believe, to the extent that these are standards at all, that the project violates any one of these standards?
I do not believe the project violates these standards.
Okay. You were asked some questions about the views from the college, Southern Vermont College.
Yes,
So you visited the Southern Vermont College.
I have.
And the document that you were shown by don't know if it's going to be entered into an exhibit, but the document from Ms. LaRue's testimony from the college. Try to see which page that is.
You're referring to MACC-MO-1,
Yes.
the aesthetic report?
Yes, the aesthetic report, which has a photograph from, it was one of the first ones that you were asked about. It's on page 2 of that exhibit. The photograph with the rock wall in front and the apple orchard behind it with the monument in the background. You've seen that photograph?
I have.
And does that, in your opinion, reflect what I would call a normal view or like a 50-millimeter lens view of the project site and the monument from that location?
Objection, lack of foundation.
I just asked the witness if he's been to this location.
But he has not taken pictures there, he hasn't produced any photographs that he would be able to compare and to opine about, unless he has.
That's
But you
fine.
haven't laid that.
I will, I'll show you what's been marked as exhibits, CM Cross Leon 1 and CM Cross Leon 2. Do you have those documents?
I did.
Did you prepare those documents?
I did.
Do all the parties have copies of these documents?
Yes.
Is there a copy I can see?
Yes.
So these have been marked but not entered.
That's right. Can you explain, you said you prepared these, but can you explain what you did with respect to the preparation of exhibit Cross Leon 1?
Cross Leon 1, that is the image on.
Objection, Your Honor. This is a cross-examination exhibit that now the petitioner is trying to put into evidence through their own witness. This is not cross-examination.
When I see marked as cross exhibit 1, Leon 1, is MACCL, MACC-ML1 at page 2. It's the same photo. So I'm going to overrule your objection.
But I guess I don't understand, is this...
Because it's already in evidence. Or it's already been offered. It's already in evidence.
But it was put in by my client, not by this gentleman.
It's in evidence. It's available for him to be questioned about.
Okay, but she asked him if he prepared this photograph, and it's not his exhibit. I
Okay.
don't understand. I'm
You can
sorry.
re-ask your question.
And to clarify what I'm trying, I've had questions for the witness, and I was told I needed to lay a foundation. Mr. Busher, so the photograph that is mid-marked as Cross Leon 1 is the same photograph that appears at page 2 of Ms. Leon's aesthetic report, correct?
It is.
And it's just been enlarged.
That's correct.
There was no enhancement or manipulation of the photograph?
It's simply a crop of that page from that exhibit.
Okay. And then what's been marked as Exhibit Cross Leon 2, can you please identify and explain what that is?
That was a photograph I took from Southern Vermont College trying to approximate the same view taken with a normal lens setting.
And what are your conclusions about?
Objection. So this number 2 is not in evidence presently?
I'm questioning the witness on this document.
She's laying a foundation for the document.
Right, but
So what's the nature of your objection?
that it wasn't put in by whatever deadlines you people have, and...
Because it was developed as a cross-exhibit, is my understanding.
But she's not cross-examining any witness right now. This is her own witness, and she's just trying to put in a document. It's like if I put Maru up there and said, here, Maru, you created this photo simulation. Let's put it in evidence, and you're telling me I can't do that. So she can't do it with her witness. I thought everything had to be in ahead of time, and you're telling us we can't put in...
Cross exhibits and exhibits that I did offer at the beginning of the day. And if there are exhibits that the parties wish to enter and have not already been entered into evidence, they need to be provided to the other parties.
Okay, but for cross-examination purposes, this witness is not being cross-examined.
I'm going to overrule your objection. You may ask the question.
I think the question was, can you explain, and you, I don't know if you, I think you were, do you want to read that on the record? It's my book.
The question, there was not an answer yet, so the question was, and what are your conclusions about? That's the last question.
Let me go back because it's a little confusing how it really ended. Exhibit cross Leon 2.
Yes.
That's a photograph, correct?
That's a photograph that I took.
So you took that photograph, and when was that taken?
That was taken on Monday.
And what type of lens did you use?
I was using a 50 millimeter equivalent lens on the 35 millimeters cellular camera, so that would be considered a normal lens setting.
All right, and when you say normal lens setting, what does that mean?
It's been accepted for the creation of photographic exhibits that is the lens setting that most appropriately represents human activity.
Okay. And going back to what is in Exhibit MACC ML-1 at page 2, do you have a sense of whether that photograph was taken with the 50 millimeter lens?
Objection.
What's the objection?
Lack of foundation.
Overrule. May answer the question.
So the point of me taking this photo after examining exhibit MACC ML-1 was I just happened to be going back down to the site to refresh myself, and this exhibit didn't look prospectively great to me. So by framing the wall and lining up the monument with where the step in the wall was, I was able to ascertain whether the photograph provided on page 2, and then we see what one would have been taken with a normal lens. And it appears to have been taken with a telephoto lens, which creates significant distortions in the perspectives of an image.
Objection. This is lack of credibility and expertise. This man is not a photographer, and I don't understand why this exhibit is being allowed to be
Well, he hasn't
evidence.
sought to offer it into evidence yet. She simply used it to refresh his recollection about his opinion with regard to the piece of evidence that you offered already.
He did
So
not
this
say that he didn't remember.
I am not going to engage in argument with you, Ms. Dean. If you're going to engage in argument with me, you can do so from outside.
Excuse
If you
me.
want to make an objection, you must wait till the person talking stops.
Excuse me.
Can you wait till the person who's talking stops?
Not if you speak to me like this, pointing your finger at me and threatening to throw me out of this proceeding like you
Well,
did
you
10
need to show
minutes into it
respect to
this
the-
morning.
You need to show
I've never been
respect to the
treated like
commission.
this.
You are abusive, you've abused this witness, you've abused other witnesses. I will not take that abuse. If you're going to talk, if you're going to ask a question, that's great, and I'll respond to it. But you do not interrupt, which you have done repeatedly throughout this hearing. As I was saying, what's been marked as cross-exhibit 2 has not been offered into evidence. It was used by the petitioner to refresh the recollection of the witness as to his understanding of what was entered into evidence as MACC-ML1 at page 2.
May I make
You
an,
may continue your questions.
may I make a statement for the record, or I don't know what to call it, an objection?
When it's your opportunity to, yes.
But it pertains to what you just said, refreshing recollection, which He didn't say that he couldn't remember something and needed his memory refreshed, which is
You're absolutely right.
prerequisite.
But that was the purpose that she used it for without making that statement.
But-
And that's how I'm gonna treat it in this setting. I'm not going to engage in an argument with you. Okay. Do we have additional questions on redirect for this witness?
I don't even remember. Just a moment. One final question. Are you aware of whether there are other commercial solar facilities cited in the Rural Conservation District?
Yes.
Objection outside the scope.
It's not outside the scope. There were a lot of questions about what's allowed in the Archon District.
Not other projects that have been, that has nothing to do with this. And it's way outside the scope. And we're supposed to be in a funnel, getting smaller and smaller. We don't get to ask stuff that hasn't been asked the last time.
I don't even know where to begin. It's absolutely relevant whether or not something other than residential development is allowed in the Rural Conservation District. It's very relevant if other commercial solar projects have been allowed and are cited in the Rural Conservation District. And unless
I'm going to overrule the objection. I believe it is within the scope. This witness, in fact, did talk about having observed other documents and other projects in the area while he was on cross-exam, so it's within the scope.
Then I would like to object because it's duplicative and it is wasteful of our time. It is in the record. In multiple cases have been put in. I think it's Mr. Wilson's testimony about all the other projects that have been, permitted, and the town
You may ask the
didn't,
question.
and the town didn't do anything about it.
Can you please turn to page 22 of your report, Mr. Busher, which is Exhibit MD-3?
Yes.
That page talks about the Rural Conservation District, and to refresh your memory, you can look at page 21 to see the source of that.
I'm going to object about leading questions and giving somebody testimony to read. Can we just ask the person questions? That's what a live hearing is for, to ask them questions, not have them read their testimony, to refresh the recollection when they haven't even said that they don't remember something.
I'm trying to move this
If you could
along.
restate the question.
All right, Mr. Busher, can you please look at page 21 and 22 of your report, review it, and to the extent you need to, just refresh your memory on what is contained on the bottom of page 21 onto page 22?
This is improper. It is leading, it is giving him information. If you have a question for the witness, you need to ask the question of the witness. If he says, gee,
Sustained.
I
Ask
don't
the question.
remember.
Mr. Busher, is the Rural Conservation District a zoning district?
Yes.
And are the standards for the Rural Conservation District with respect to allowed uses, these are all zoning standards?
They are.
And this list that you are showing on page 22 from table 3.13 of the town zoning regulations does provide a fairly long list of allowed uses that are not residential. Is that correct?
It does.
And
That's
did Ms. Dingeldine refer you to this list when she was cross-examining you earlier, to the best of your recollection?
No.
Is this the document that you were referring to when you said there are other land use documents that allow uses other than residential?
Yes.
I have nothing further.
Nichols?
Nothing. Except I would like to put on the record that despite your sustaining my last objection, The witness sat there reading the materials in front of him while the questions were being asked. So it's the same difference. It's just like leading him because he sat there reading it. Just my observations.
Ms. Dingleby, I'll remind you that the statements of counsel are not evidence, only the statements of the witnesses. Do any other members, any other parties have questions for this witness? Very well. Mr. Bush, you may sit down. Thank you for your testimony.
Yes, Mr. Kane, can you please state your full name for the record?
Mark David Kane.
And what is your occupation?
I am director for the Front of SE Group.
And the witness is free to be sworn in.
Can you swear or affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth?
I do.
The witness is free to be cross-examined.
Mr. Kane, how are you?
Good for you.
You familiar with the Archon standards?
Yes.
I believe that they are contained at exhibit MACC-ML-7. That's LaRue, Leon's
Do you have a copy for the
yeah,
witness?
this is, it's with her testimony. For rebuttal, I think.
That is, he's got the petitioner's testimony.
I actually have her testimony.
Okay.
So it was MACC, excuse me?
MACC-ML-7.
I am at that exhibit.
Could you turn to page 4 of that exhibit, please?
Yes.
That talks about hillsides and ridge lines. That's the beginning words on that page.
Yes.
And are you familiar with these standards?
Yes.
I'm not familiar with these things. Where did this document derive from?
These are in the land development regulations.
And the gentleman before you testified that he believed these were applicable to this proceeding and this project. Would you agree with that?
The land development regulations?
These were applicable to this proceeding and this project. Would you agree with that?
The land development regulations? No.
So, in terms of, so did you review these, this document in into your opinions in this case?
I looked at all the regulations in the town, including this document, but I still don't believe they're applicable as a community standard under preaching.
Okay. Why then, if you know, is this talked about so much, and zoning regulations are talked about by the petitioner, and why was there so much discussion about all these different standards besides the town plan if they're not applicable?
Well, one of the challenges I think that this docket has suffered from is the fact that the town plan, 2010 town plan, sort of commingles its land development regulations with the town plan language. There's a lot of overlap and similarities, so there's not a very distinctive line between the two at times in terms of language. As to applicability to the preachy, I have relied on the town plan language.
Okay. And so you do not believe that the reference to particular standards that are being referenced in a document like this apply in this proceeding because you think it's confined just to the 2010 town plan? Fair to say?
Yes.
Okay. All right. That's fair. We've had a couple meetings before today. We had, I cross-examined you in Apple Hill Solar.
Remember what?
And then a case before that.
Middletown Springs, there we go.
Middletown Springs. So my question, I want to go very briefly through this. It's my recollection from your testimony before that you regularly worked for either public service department or petitioners in this process in terms of your involvement expressing opinions about the Queechee analysis and whether there's aesthetic impacts or orderly development impacts. Fair to say?
Yes.
And almost without exception, the overwhelming majority of your cases, you have opined that there was no undue adverse impact to the aesthetics of the area based on your analysis of the Queechee test. Is that fair to say?
For the majority of them, yes, not exclusively for sure.
And you may have had one or two opportunities where you've met with a client and just said, this doesn't pass muster, and then you didn't continue to be employed because they were dissuaded from going forward with the process. Fair to say?
Or I was no longer under their employ.
Okay. So I just wanted to ask you very briefly about three cases you were involved in. That involved wind. You were involved in providing a Queechee analysis on aesthetics in Deerfield,
Yes.
in Lowell,
Yes.
and in Sheffield.
Yes.
And in all three of those cases, you determined that there was no undue adverse impact on the scenic and natural beauty of the area.
Refresh my memory for a few of them, they're quite far back. My recollection under Lowell was that I did originally conclude that there was an undue adverse impact, but there was some subsequent changes to the plan that ameliorated those impacts.
So, you have been involved in the prior proceeding relating to, that was called Chelsea Solar, whether it was a different case or this case, you were involved in being the expert on that portion of the case, fair to say?
Yes.
And that was a case that was denied on aesthetics and orderly development by the Public Utility Commission recently, correct?
Yes.
Okay. Did you have occasion to review the decision of the Public Utility Commission?
I did.
And so I wanted to ask you and give you the opportunity.
I'm going to object. If we're going to go through what will take an hour to have questions read in from the record speaks for itself. This is a different case, and the project has changed since that decision was
I'm not
issued.
overruling the objection, you may ask the question.
So in my looking at I think Mr. Wilson had some maps that he shows where the fence is going to be and where the clearing is going to be of that project versus this project to demonstrate how it's been altered. You're familiar with some of those exhibits?
I have some recollection of those exhibits, yes.
And then they were superimposed on one another, so you can really get a good idea of the exact difference.
I would need to see them again to refresh my memory, but I'm aware of them, yes.
Okay. So I looked at those, and then I looked at the acreage, which I think we've established in the record, has been reduced for the clearing of the site by less than 1 acre.
I believe that's an error. I believe that the order from the PUC actually had the acreage wrong in it, and that the acreage that they cited in that order was actually the acreage for the Apple Hill project. And my recollection, again, not having looked at it in a while, but my recollection was that the actual clearing for the Chelsea project was more like 13.8 acres. So the net difference was not 1 acre, it was 4 or 5 acres, 5 acres.
So there were some calculations in some of the materials that talked about the percentage of decrease that it was shrunk, and I recall reading 40%.
Yes, I believe I've seen the number of 40% as well.
Okay. Do you know who did the calculations on that? Because I'm not sure the math is right, even given your indication of the acreage.
Yeah, I don't recall exactly who did the calculations, but my review of the difference between the two projects was, I think there's a 32% reduction in the actual clearing, or a 33% reduction in the actual clearing, and a 40% reduction in the area within the fence. So as you might recall, as you know, I think it's a matter of fact here, the array has gotten smaller in terms of being closer together, the arrays, so that the fence line actually has shrunk disproportionately to the amount of clearing that has changed.
The other thing that I seemed to notice was that now there's some buffer instead of clearing all the way to the property boundary, I guess, on the west or southern side, sort of where the highway area.
That's the west side.
That's the west side. Okay. So some tree buffer is being retained that was not previously, fair to say?
No, actually, there was a buffer previously. I think the buffer has increased by 50 to 60 feet. From originally, I think it was 150. Now it's more like 200. So there always was a buffer in even the original docket.
Okay. What's happened to the buffer on the north and east side? Has that been reduced?
The north side buffer, I don't believe it's changed much. A little bit. The east side buffer is the east side. You're requesting, or south side? East.
Well, we'll get to south in a minute.
Yeah, okay. We'll work our way around. On the east side, I can't recall exactly what the buffers were, but I believe it's not changed significantly from what it was originally.
Has any of the Chelsea 1, I'll call it, project clearing area, has any of that been absorbed into the Apple Hill project?
I haven't done a detailed analysis of the differences in those clearing areas in terms of the net effect and net balances on the property. Mr. Wilson may actually know that.
Okay, we'll be sure to ask him. Do you agree with the Public Utility Commission in terms of the town plan having a clear written community standard that's applicable in this case?
No.
So then I guess you don't think any clear written community standard has been violated if none exists?
Correct.
my understanding that the Vermont Supreme Court decision known as Rutland Renewable Energy established that neighbors are considered an average person under the Queechy test? Do you disagree with that?
I don't disagree that that was the decision. And I think there is some space within which the consideration of neighbor impacts or resident impacts is important, but whether or not they're given the same status as an average person under the second prong of the Queechy test, I think is a misapplication, from my opinion. That being said, in this docket and in many dockets that I'm involved with, we take significant strides to understand and evaluate and in many cases ameliorate the impacts of those most closely affected, which tend to be residents and neighbors.
But you also take the position that neighbors are not average people, or the reasonable person standard, right?
Yeah, I think that the decision that was reached in Rutland Renewable was sort of a continuation of the evolution of our understanding of how projects like this fit into the work, to the Vermont context, and the recognition that we need to make sure we don't ignore the impacts on residents. So, again, from my perspective, I apply, I think, very liberally, if you will, the test under Queechy for shocking or offensive to make sure we don't ignore whether they're given the same weight as a quote average person. Is, in my opinion, is a different matter. I try to weigh the average person to be it's an abstraction. It's trying to find disinterested persons so that we can make an objective decision about the potential aesthetic impact of the project. That being said, I'm not blind to the fact that there are people that live in and around the projects I do consulting for, so we try to find a balance between those two things. I do.
But you disagree basically with the Supreme Court that those private folks, those that may have some private interest, you don't feel that they're on a level playing field in terms of their opinion, just because they are biased?
I'm going to object. I don't have a copy with me, but I'm very familiar with that case, having tried it. And I think it's inaccurate to characterize the ruling in that case the way counsel has done, and it may be misleading the witness.
Sustained.
Not leading, but misleading.
So on your rebuttal testimony on page 6, that's the August 10th rebuttal.
Just a moment, please. Yes.
And line 13, you were asked the question on page 25 of his report. Raphael, who's DPS's expert, states that while some of the neighbors would find the project offensive, they aren't considered an average person under the second prong of the Queechy test. And then the shocking offensive question is asked, and you're asked, do you agree? And your answer was yes. As discussed in my report and pre-filed testimony, while my analysis has considered potential impacts to both the broader public and from neighbors, I agree with Raphael that such private interests are not recognized.
I'm sorry, that's
Oh,
such was. No, just.
Where are you?
Private
I
interests.
agree with Raphael
That such private interests are not recognized as, quote, average persons, unquote. And even if they were, the project does not shock or offend an average person. So that I'm not misstating anything or misleading anybody. That was what your testimony was. What has private interests got to do with whether or not, from a particular vantage point that might be a private property, there is or is not an undue adverse impact by, as a result of someone perceiving it as shocking and offensive?
Okay, so parse that out a little bit. So the Queechee, my interpretation of the Queechee method is that it does give significant deference to public vantage points, in part recognizing the importance that the public has to views. There's an important aspect of preserving one's scenic qualities and making sure that from public vantage points, those views are preserved and at least evaluated. I don't believe anything under Queechee I don't think Queechee was intended to prevent development anywhere from every vantage point. So I think the distinction that I'm making, I think Mr. Raphael's making, and I think Mr. Buscher's making, is that from a basis of evaluating whether something is able to shock or offend, you do look at the average person. You do look at folks that are disinterested, so that they don't come to the construct of the impact from a position of having a particularized interest. And I think that is the big distinction. If you're on a public road, there's a presumption that the public view is yours. If you're in your backyard, you have interests there that are not public interests. Those are your personal interests. So I think that my interpretation of Queechee has been pretty consistent in the sense that, and it's stated here and it reiterates what I just told you, that I do not ignore the impacts on neighbors. I think that's a very important and good thing to do relative to developing projects like this or any other project for that matter. But you can't give the same weight and consideration under the Queechee test to one particular neighbor over the sum and substance of all public vantage points.
Okay, but you see, you're mixing two different things from what I understand what you're saying. Don't you agree with me that there's two different things that you're talking about here? There's whether someone is a reasonable person, and basically what I think you're saying is if you are somebody who's right next door to a project, that you may have a bias, and so your opinion may be swayed because of your private interest in not wanting to see, a shocking and offensive project in your opinion, be built. Versus whether or not a reasonable person's viewpoint is assessed from a location, whether it's public or private. And my understanding is, from Supreme Court precedent, is that private and public views are both important and reviewed and looked at under the Queechee analysis. But it is the particularized interest or bias or whatever that has to be removed in terms of the individual's objectivity of what they think from that viewpoint, whether it's public or private. Do you agree with what I've been explaining?
I'm not quite following it entirely, and I think it's sort of, I'm trying to understand I think I've been clear this, the fact that I consider, when I'm evaluating Queechee with the eye towards the average person, the ability to shock or offend an average person, the methodology I employ, the consideration I give to that is where are these people who may see this project, what's their perspective, where are they coming from? And I think that the test under Queechee for the average person was to try to remove some of that bias, as you describe it, some of the sort of particularized interests to that, so that when the PUC is making a decision, they're not making it solely on the purview of one person's perspective. That being said, again, just to what I've testified in my rebuttal testimony, I don't ignore, and I think the PUC does not ignore either, the interests of individuals who may be affected by a project. But whether or not those have the same weight, to your point, I think is the question. And I think that's something that the PUC does, is it weighs the impact relative to those different perspectives and tries to find the right solution. So my job as an aesthetic consultant is to identify where those vantage points are, to characterize the impact to the average person, and to try to remove at least some of the bias, if I can.
Okay, but so what I hear you saying is, you don't think private views are as important as public views. Fair to say?
That's not what I'm saying at all. I'm saying I try to give consideration to both sets of views in my evaluation, but I do feel that the consideration needs to be reflected in terms of the broader impact. So if there's one vantage point from one private location and there's no visibility from 1,000 public locations, that does enter into my mind.
Okay, I understand. Thank you for explaining that. Okay. But the PUC goes to many, many public and private locations. And aren't they the folks who need to make that decision in terms of what they're looking at and whether it shocks or offends them if they're stepping in the shoes, to test the credibility of the experts that are telling them, yes, it's shocking and offensive, or no, it's not shocking and offensive?
PUC can go wherever it wants, and often, you're right, does go to public and private vantage points to look at the project. I mean, we tend not to go to private vantage points because we are oftentimes not allowed to do so. So that does limit our ability to evaluate that.
So, what is Mount Anthony Country Club? Is that a public or a private view?
I'm going to hedge and say it's quasi-public. I mean, it really is. I mean, I think that at the end of the day, it's a private facility, it's a private business, and it's not owned by a cooperative, as I don't believe. Or
Why do you think it's a private business? And
Well,
that doesn't allow.
No. Let me finish the question. So it's owned by somebody. Somebody owns and operates that facility. So presumably they could tomorrow say, we don't want anybody on this property. I mean, I'm just not hypothetical. So in that sense, it's a private business. It operates at its own business interests.
Yeah.
Maybe I'm wrong there, but my understanding is that it is a private business that has owners, and they can do that.
Also,
It doesn't mean the public's not allowed there. Any business, they can invite the public and allow the public to use it.
Oh, IBM is owned by somebody, right?
Whether they let the public in is another question.
Okay, but Mount Anthony Country Club, do you have some evidence or information that it's not a public facility that anybody can come to and spend money and buy food and play golf?
I didn't
Just
say that at all. I said quasi-public in the sense that to Mr. Busher's testimony earlier, that you have, my understanding is to play golf there, you do need to pay, which is different than being on a road. In Vermont, you don't pay to get on a road or a public trail or a public park, generally. So I think that there is a distinction from the locale.
So if you go to Walmart and spend money at Walmart, it's not a public place, even though they are subject to public accommodation laws and can't exclude and discriminate against the public?
Yeah, I'm not an expert in Vermont discrimination laws, so I'm not going to get into that. But I do think that there's a distinction between a place that you pay to use versus a place that you do not have to pay to go to. I mean, you don't have to buy anything at Walmart, my understanding. I've been there, I think, a few times at this point.
So is Southern Vermont College private because you have to pay tuition to be a student there?
It's okay. Let's sort of, maybe I can be clearer with you. You know, it's not a public facility. It's not a place owned by the public within the public interests. It's not a park. It's not a road. It's not a public facility. It's not the Vermont Welcome Center. It does not have that status of being publicly owned, operated, or otherwise clearly accessible to the public at all times with no interests at all represented other than that you have access to it. For Southern Vermont College, I understand is it was a private college. And again, if presuming if they wanted to, they could decide they didn't want people to come on their property. I don't know, you know, that's the basis on which I'm answering your question. I don't know what more you'd like me to opine about.
You aware that there are public walking trails all over Vermont, Southern Vermont College campus?
I have heard of, and I was at the site visit and on a previous visit to the college, and I'm aware there are some public trails, yes.
So did that enhance your concern about the shocking and offensive reasonable person response? Did they get elevated because they allow public in any time to walk on their trails, or because you got to pay tuition, they're not so important because it's...
No, again, I think that's a mischaracterization of what's important. I mean, look at everything. I think Mr. Boucher was talking about the fact you do look at the entire visual context and try to understand the impacts more broadly. For the college in general, I think one of the things that factored into my decision as to whether or not there was an ability to shock or offend from that vantage point is that in many places within the campus, you're 15,000 feet away from the project. You're 3 miles away. And you know, that does factor into my understanding of the ability of a visual in the landscape to shock or offend. So I would give it some weight for being available to the public, but also give it some consideration of the fact that it's very far away from the product that's being proposed.
How much money has your company made thus far between Apple Hill and Chelsea Solar?
Well, thanks to you. I don't know. I don't know. Honestly, I don't know what the current total is.
I think you said something like 50 or 60 grand when we talked last time at Apple.
It's a bit more than that, obviously.
Okay. You were the aesthetic expert on Apple Hill, and now you are on Chelsea. Have you done any analysis in terms of the combined effect or cumulative effect of the two projects both being permitted, and how that would alter or change the analysis under either orderly development or aesthetics?
I believe if you look through the Apple Hill filing and docket, my analysis for that docket did consider, the visual analysis for that docket did consider the presence of both projects. The simulations included both projects, the analysis represented both projects, and just to make the record clear, I started this project first with the understanding that Apple Hill was probably going to be second, but as time has come on, this project is now second. So I think the analysis that was considered under Apple Hill, that was one of the basis for the proposal for decision that's been issued in that docket, did consider the potentially cumulative effects of both projects.
Okay. So if the Public Utility Commission denied this project the last time when it was a larger clearing area, and the other gentleman said that he thought there may have been a mistake or something in the opinion about that.
I said that.
Oh, you said that, I'm sorry.
I know it's a long day.
So what is the total combined acreage between Apple Hill and Chelsea as it's proposed now?
I'd have to go back. I can honestly not remember the Apple Hill number. 9.64 plus whatever the Apple Hill number was. I'm sure Mr. Wilson can
So it
rattle
was
that
10
out.
acres for Apple Hill?
Oh, 10 acres? I believe it's under 10 acres, but I can't remember exactly the number.
Just one moment, please. ask you briefly about, in your testimony, you said that you observed 2 solar projects,
So which testimony are we talking about, please?
rebuttal.
On what page?
Page 13.
Yes.
Line 8.
13, line 8.
You said that you observed 2 solar projects that were in very close proximity to a public travelway, Route 7,
Yes,
and where no screening was proposed.
yes.
But you didn't, I noted that you didn't say that you could not, that you could see them from Route 7. And I've never seen them from Route 7. Are they visible from?
Yes, if you go to CSMK4 and you look on sheet 1, figure 1, there's a little E all the way at the left-hand side. And that correlates to photographs I took of the solar project on sheet figure 4. This is, I think it's near the state police facility.
Sure.
So, you think those are undue adverse impacts?
I haven't analyzed them. I think the purpose of my testimony was just to note the fact that there are other solar projects in, proximity to Route 7 that are, in this particular case, unmitigated. And to make the point that was a, if I had been working on the docket, for some reason I get lucky, I would have probably had a lot of mitigation to propose.
Okay. So the point being, they should be screened because they're shocking and offensive?
No, I think it was more to a point of whether or not in the town's consideration of other solar projects that they've been consistent in the application of both their town plan language as well as their solar screening ordinance. And, I don't know exactly the timing of this one, but if projects are to be screened relative to the screening ordinance, then this one seems sorely lacking.
Okay, when did the screening ordinance come into being?
I have to remember, I think it's 2016, as I recall.
And when was this permitted?
I don't know exactly when this was permitted. That's why I qualified my answer.
Right, so we don't know whether that was in effect or not.
The town plan language was certainly in effect.
Right, but the town is not responsible for permitting under their town plan. It's not a regulatory
No,
document.
but they can participate in PUC.
And they can spend $200,000 and then have to negotiate out of it because
Objection,
they spent a lot of money, right?
Objection.
Sustain,
that's
you want to
He
avoid
opened the
making
door.
speeches, if you can, please.
He opened the door, and if he's...
Precisely, what's the nature of the evidence that you're trying to achieve from this witness?
The gentleman testified that the town can do whatever they want to do to intervene and be heard on a particular docket, but we are in a particular docket where they have had to bow out and make a
Objection.
decision to accept $200,000
Objection.
and not to protect their town plan or to continue to litigate this.
Objection.
So,
So you have a question,
I do.
which is,
So, there are other reasons why towns do not involve themselves in the Public Utility Commission process. Fair to say?
I can't speak for every town, but they can make a decision if they want to or not.
Specifically Bennington. There might be other reasons why they were not involved in those dockets, or why they won't be involved in
The
dockets in the
witness has
future,
already
right?
answered. Objection. The witness has already
He answered
you want to
any
overrule the
town.
objection, you may ask a couple more questions in this area.
So if we just maybe repeat the question.
So Bennington, in fact, may have other reasons why they have either not been involved in a project in the past, or in fact, definitely will not be involved in a project in the future, right?
Yeah, I think that's a question that would be best asked to Bennington. I mean, I can't opine as to why they would choose to participate or not. My point is that they're allowed to participate with the Public Utility Commission on dockets that relate to solar development. So whether they choose to do that or not is up to them.
Right. But there may be other reasons other than reluctance to enforce their screening ordinances or town plan provisions. Fair to say?
I think he's already answered the question, and he said that it calls for speculation and he didn't want to do that. Is that correct?
Yeah, I just, I don't, I do not know why, I have no understanding of why they would decide not to, but my point still stands is that can be one of the outcome of that particular project is clearly not one that shows a lot of screening. So some decision was made, whether it be through the town plan review when they were looking at the town plan and looking at the project that was before them, to not participate or to participate and not require additional screening. I do not know what the basis for that decision was.
How many proceedings for energy projects have you been involved in your career before the Vermont Public Service Department or the Vermont Public Utility Commission?
I think I'm over 30 at this point, but I can't recall exactly.
Of those 30, how many of those proceedings involved active participation of a town in the proceeding where they hired a lawyer and actually engaged in the full-blown testimony process, to your recollection?
I don't have a number. I would have to speculate. It's not a significant percentage,
Or a small percentage?
except in New Haven. They've been participating a lot.
And the number of individual interveners is also quite small, is it not?
I would disagree with that. I think that in many of it, because of a lot of the work I have done with the Department of Public Service, a lot of those proceedings do have, at least at some level, whether they stay on throughout the entire proceeding or not, or but there's been a lot of intervention, or at least interest and concern about projects from neighbors, and some choose to intervene, some choose to intervene for a while and then don't want to intervene.
How many of those individuals that you've encountered had a lawyer?
Objection. I don't see the relevance of this line of questioning to the testimony that this witness has offered.
Do you have a response? How
Because-
is this relevant?
because
How is the
he's-
question about pro se representation relevant?
Because of his response to the last question.
I don't understand.
This is not an evidentiary issue that this witness has provided any testimony on. If
He
Ms.
just
Singleton
did.
wants to brief it, she could brief it, but it's not relevant to
I-
the testimony he's offered.
I'm not willing to sustain the objection here. I want to understand why this is relevant.
Because he responded in a way with an answer that indicated
I understand that, but why is it relevant?
it is meeting the evidence that he just testified to. So if you want to strike his answer, then I would move to strike his
Okay,
answer.
what's your question?
I don't even remember anymore. I'll just move on.
Okay.
You indicated on page 12, line 21, that the applicant has retained vegetation along its entire periphery of varying widths.
I'm sorry, which exhibit you looking at?
The same one. We were just on 13, so we're going back to 12, page 12.
Is this the August 10th?
Yep,
And page 12,
yep,
and what line, please?
21.
Yes.
Is that true that the applicant has retained vegetation along its entire periphery of varying widths?
Yes.
Well, so I understand they maintained vegetation along the west, the north, and the southern borders. But I thought that they were proposing to cut all vegetation on the eastern border. Is that not true?
All trees, yes. Vegetation, no. There's a distinction.
Well, what, is there vegetation other than trees that provides any significant screening?
Certainly. Shrubs can provide great screening.
Yeah, but not 50 feet high.
Well, no, it doesn't necessarily need, that's not necessarily what the intention of the screening is. It needs to be there. So I think that the point is there is much more forest vegetation left on the periphery of the north and the west and the south, but On the east, it's largely clear, but there's still vegetation there.
All right, but all the trees are getting cut, right?
Yes.
Okay, thanks. That's all I have, thank you.
Thank you.
Rita?
I have no redirect.
Do any of the other parties have questions for this witness? Mr. Kane, I want to thank you for your testimony. You may stand down. Why don't we take a break until, a shorter break until quarter after the hour, and then we'll begin with Mr. Wilson.
Would we be able to have my clients go next since they cannot return tomorrow? And I assume Mr. Wilson would be here anyway if we needed to go over Littleton tomorrow. If
Is
there's
there any objection?
I don't have any questions at this point for Ms. Block. We do want to offer in and have admitted the cross-examination, as in lieu of cross-examination, the discovery responses from the homeowners association. So
Okay,
we,
so you want, so you need both of them. Is there any objection to them going before Mr. Wilson?
I don't need both of them, is I guess what I'm saying, that we don't, there is no objection.
Okay.
But I think that, and I won't have very long cross-examination for Ms. Leon, so there's no objection.
Okay, I think we're going to go ahead and make the swap and put, is it Ms. Block first, followed by Ms. Leon, and they will be available for testimony at 20 minutes after the hour.
Just to clarify, I have no questions for Ms. Block.
Okay, okay.
Is there,
This will
Adjourn.
take, this will come very fast.
I don't understand, so you're putting in cross-examine exhibit, cross-examine.
It's common practice to have cross-examination, we're trying to get it done.
I know, but
And I can ask her every question, and she can respond to it and read from her answers, or we can just admit it and eliminate
How are you?
cross-examination. That's the only thing that I would have done, was have her authenticate her answers. I don't think it's necessary if you're willing to stipulate them in.
well, but I want the opportunity. She may need to explain something, or I may want to redirect her on.
So you're going to object to the admission of her discovery responses that were provided under oath?
They may need context, like your clients or your witnesses.
We'll consider that.
I mean, I can't imagine it's going to be more than 5 or 10 minutes. I don't know what the problem is.
Did they use an axe?
They did use a tourniquet. What's that about? Yeah.
Have we resolved what's going to happen next?
Yes, I don't have any questions of Ms. Block, and we will not be offering any cross-examination exhibits for the Alcohol Homeowners Association. I have some short questions for, in terms of time, Ms. Leon, which probably can be done, I think, in 10 minutes.
Okay,
Maybe not even that long.
are we ready? Let's go back on the record then. What are all these binders that are on the witness table?
Those are
For you? Oh, I don't want to hide. Oh, I don't want to.
Yeah, that's a good
look
point.
through all those.
Yeah.
Oh, right, those are
That will take more than 10 minutes. Identify the witness, please.
I'm Mario Leon from Mount Anthony Country Club in Bennington.
Ms. Now, if you could raise your right hand so after me, do you swear or affirm under penalty of perjury that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Thank you. I have,
Did you have something you wanted to say before you offer the question again?
Yeah, just one housekeeping issue, because there was mention of interrogatories that weren't signed or notarized or something. So I thought an easy way to remedy that would just be to ask my witness if all the discovery responses that she's provided were true to the best of her knowledge, and just do a verbal notarization of it, or...
I didn't intend to ask any questions about the discovery.
Okay.
Oh.
Thank you. Good afternoon. So I'm referring to your report, your aesthetic report, MACC-ML-1, and I have a number of questions about that.
Okay.
Let's turn to page 2, the photograph. It's entitled Photographer's Images, Ann Smith. Who is Ann Smith?
She's a local photographer who sells her photographs in town.
And where did you obtain this photograph from?
Bakerisch, it's an Austrian bakery in Main Street.
And do you have any personal knowledge of what type of camera or lens was used for this photograph?
I don't.
You don't know if this was from a 50 millimeter lens?
I have no idea.
Okay. Do you know the year?
No, I don't know the year.
Okay.
I bought the magnet by coincidence many years ago, and I've had it in my refrigerator.
Okay. Well, similar question for the 2 photographs on page 3 by Dave Kuchakian, Kutschukian. Do you have any personal knowledge of the camera that was used, or the lens that was used for these photographs?
I do not.
Do you know where the photographer was, or I should say, do you know where, whether it was on the ground or aerial, where these photographs were taken from?
I do not know where he was standing. It doesn't seem to me that they were aerial photographs. It sounds to me like it was just from a higher point on the same piece. I think those are from the apple orchard, where we did the last visit during the last stop in our site visit.
And so, but you don't have any personal knowledge, you're speculating?
I'm speculating. These are all photographs, by the way, that are all public photographs that these photographers use to sell, to promote. They do note cards, they do postcards, they have, they're all vehicles for them to make a living. They're all artists residing in Bennington.
Do you, and you don't know whether these are zoomed in or zoomed out, you don't have any personal knowledge?
I don't even know them. I don't even know these photographers, so I wouldn't know.
Did you see that both of these photographs say at the bottom that they're copyright protected?
Yes.
Did you get permission to reproduce them?
We called the people that were, and they said that that would be fine.
Okay. Similar question, page 4.
Yep.
Do you have any personal knowledge as to, this again was a different photographer, not yourself, as to what type of camera or lens was used for this photograph?
I do not.
Okay. And same question for page 5. There are 2 photographs from Greg Nisbet. Do you know what type of camera and lens were used?
I know Greg more personally because he takes photographs for me and for my family and for the country club. But I have never asked him what type of equipment he uses for his work.
Whether he uses a 50 millimeter lens?
I have never asked that question, whoever it was.
Okay, the photograph on page 6, which is the panoramic.
If I could ask a question just about the one on page 5. Do you know when these photos were taken?
It doesn't say it in there.
Just a phone number.
I would imagine they were from this year, 2017 or 2016. He
But
has.
you don't know for sure.
I'm not sure. I mean, I could definitely bring that back into the record because he documents, he takes photographs for us every year. But I know that they're not from 2018.
And on page 6, there's a panoramic photograph taken by Greg Nisbet
Yeah,
from the NESBIT,
from the monument.
Bennington Battle Monument. Did you Did you download that from the website that you provide under the photograph? Is that where this exhibit?
I actually, I asked him for photographs, that if he had ever taken photographs from the monument that I wanted to see, and he said, oh, actually, I have this great photograph that I've taken, that it's a panoramic. And I said, oh my God, how did you do this? And he explained to me how it's very easy to do that. You just put it into your iPhone, and there's a panoramic feature, and it connects. You basically stick your camera out, which is what everybody does, by the way, in the monument. You stick your camera out on the opening of the monument, and then you go like this, and then you go to the next opening, and then you go like this, and then Apple, basically, the application for the iPhoto connects the horizon line and connects all of the points on a 360 degree.
What about the photograph below it, which says it's a full-size panorama? It's different than the one above.
What that is I did that, and what that is a close-up of the proposed area, and that was for my point, for my usage to try to do simulations. I went into Greg's photograph with his permission to basically isolate the area where the proposed project is being, for the project being proposed.
You went in and, I mean, it looks to me like what you did was zoom in, because I can see the area in the distance on the panorama above, but it looks that you really had to zoom in quite a bit to show what you have shown as the second photograph, correct?
Correct.
Do you know how much you zoomed in to achieve that larger scale view of the project site?
I could probably answer that easier if I brought my exhibit that I have with the simulations, because that's exactly where I went in to do that from.
You don't have your exhibits with you?
The exhibit that I did on the simulation that I brought in today. This one. So what I did is,
Just for the record, the witness has been handed the piece of demonstrative evidence that previously been used. Is this the one with just two pictures on it?
this is the one with the two pictures.
Okay, can I see it, please?
Yes.
Oh, this is the same as the one before. Okay.
Yes. Actually,
So it's,
don't you look, okay, so actually I thought that I had here the monument, but basically what I did is that I zoomed in into this area and brought it, I mean, what percentage? I would imagine it would be at least 300% from the point of view, from the exact point that I cropped in.
Okay. And then, I don't think we have to go through each one of these. You have on pages 7 and 8, you have photographs of Lee Crone, K-R-O-H-N, and John Davis. Do you have any personal knowledge of the type of camera or lens that was used for these photographs?
Again, I do not. These are professional photographers who do this for a living, and these are images that are on their Facebook pages, on their websites. They're sold in the local stores as cards and postcards.
And I assume that you superimpose the arrows that appear on pages 7 and 8?
Yes, those just to identify how visible the proposed area is from this point of view in the town.
And page 9, there's a photograph. Where did this come from?
Sorry, page 9, let me look that up. Page 9, it is a photo taken off the website from the apple barn, which was our, from the apple orchard, which was our last visit during the last stop during our site visit, when we all did that site visit. So this photograph is on their website for the apple barn, who owns the apple orchards.
Do you have any personal knowledge of the location from which this was taken, whether it was on the ground, along the roadside of the apple orchard? Was it taken from an airplane or a drone above the ground?
I have no idea.
And I take it that you have no personal knowledge of the camera or lens that was used?
No, again, no, again.
Similar questions for pages, the photographs on pages 10 and 11. Do you have any personal knowledge of the camera or the lens that was used for these photographs?
No, I do not.
Page 13 is a photograph that it says that you took. It's a little boy.
Page 13?
Yes.
Yeah, that's my daughter.
Oh,
Oh,
page-
wait. Which is page 13?
Page
That's my
13.
son, yes.
Oh, that's your son, okay.
Yeah.
And then on the cover page, there's another photograph that it says that you took that?
Yeah,
And
both of those are mine.
they're both your photographs and
Yeah.
both your children?
Yeah.
Okay. I was just curious, were they taken from the same location?
Yes, they were.
They both say 2008, so they were standing in approximately the same location as their photographs?
Identical location.
Okay, and these were not taken from a fairway, but above a fairway?
They're right above, they're on hole number 7, I believe, and they're from the fairway, like on the higher point, the higher elevation from the fairway.
Okay. Can you explain why the photograph of your daughter on the cover shows the site, the project site being much more distant than the photograph of your son? The image looks different to me, looking at comparing those two photographs.
I think they're not standing in the exact same spot. The reason I wanted them together, and that was my Christmas picture that year, and I ended up having to put them next to each other, 2 pictures, because they didn't want to take them together. At that age, they don't really like each other very much.
Oh.
So I don't know exactly how far apart they were standing, but I took a picture of him and those were taken with my phone.
With your iPhone?
Yeah, with my iPhone.
Okay, so let me, but how far apart were they standing when you took the photograph?
I would say a few feet apart.
Okay, and your iPhone, to your knowledge, does that have a 50mm lens?
I wouldn't know.
I have nothing further.
Mr. Redirect?
Thank you. So, the aesthetic report, photographs.
Mhm.
Page 1, your beautiful daughter. You took that photograph in 2008, correct?
Correct.
Does that photograph, is that a fair and accurate representation of what you observed with your own eyes at the time at which you took this photograph?
Yes.
Same question about the back page, your son.
Mhm.
Is this a fair, you took the photo yourself,
Correct.
is this a fair and accurate representation of what you observed with your own eyes at the moment at which you took the photograph?
Correct. Yes.
Okay. And I do notice that one is just enlarged. The boy, your son's photo is larger on the page.
Mhm.
And your daughter, because you have the aesthetic report.
It's a smaller image.
You made the actual.
I made more room for the title
Sure.
within the page.
Okay. But other than that, you were in the same approximate location on hole number 7, standing on the fairway, taking the photograph. Going to the second page, Ann Smith's photograph
Mhm.
with
The magnet.
the wall,
Oh.
the magnet photo where you have the beautiful stone wall. Have you ever been at that location?
Yes, many times.
And you have looked out at the Bennington Battle Monument where you've been standing there?
Yes, many times.
To your recollection, is this a fair and accurate representation of your recollection of the view from this approximate location?
Yes, especially when you're on the deck.
Let's switch to the Dave Kachubian. In page 3, this is images taken from southern Vermont orchards.
Mhm.
Is that an area that you're familiar with at all?
Yes, I visited the orchards.
Okay. so these two images that were taken, one looks like it's the orchards themselves, and then the bottom one shows a red barn in it with a lake or pond.
Mhm.
I'm sorry, what was the answer? You
Yes.
Yes.
From your recollection of being at the Southern Vermont orchards, are these fair and accurate representations of what you experienced as the view from those locations?
Yes.
I would assume page 4, you probably don't know the exact location, or, oh, is it Eddington House Inn?
That's where it came from. The gentleman who took that photograph, I tried to contact him after I saw the picture at the Eddington Inn. And the only reason I knew that is because I do some stay and play packages with the Eddington House in North Bennington, and I had seen that picture. But the photographer had had a stroke, and I wasn't able to communicate with him, so that's why that picture is such good quality. It's the only access I could have had to put it in, but I took it right off the Eddington House's website where they feature all of his photography.
And just in terms of, that's an area, to your knowledge, that you can see the Bennington Monument from?
Yes.
And it does look out towards the solar
Towards
array area?
Yeah, towards the gateway towards Route North 79.
Page 5, Greg Nesbitt, who took these photographs for you either in 2016 or 2017. Tell us where on the golf course these two photograph views are taken from. Can you tell us, is it a deck, a certain hole?
No, they're from the golf course, and they're I believe, and I don't have them in front of me because I left them back in my desk. But I believe the first one is from hole number. Yes, so the top photograph is from hole number 10, and that's the green from hole number 10.
Is that a fair and accurate representation of the photograph of you, to your recollection of what you saw when you stand in that location?
Yes.
Okay. And the bottom one?
The bottom one is the view from the tee box from hole number 8, or the fairway. I mean, the tee box from hole number 8 is a little bit farther to the left, but this could have been taken from there, or from the fairway of hole number 11, which is the green that you see below, where you see that person putting below.
So those two locations are right next to each other.
They're very close. They're very proximate. Yeah.
Is that a fair and accurate representation when one views towards the solar array proposed site?
Yeah, that is a view. You can see very clearly the highway right where you're in those locations, and the hill where the proposed Chelsea project is.
So the next page, page 3, 180-degree panoramic photograph by Greg Nesbitt. This is what you were describing about the panorama that,
Yes.
that you were told how to do. Have you been up to the top of the Bennington Monument?
Yes, many times.
Have you ever taken a photograph?
Many times.
And have you ever stuck your camera out the window and done this?
It's the only way to take a picture when you're up there, because what the other gentleman said is true. The stone is very deep, and the opening is only like 1.5 feet wide or 2 feet wide, and so your view carries the depth of the stone. If you want to see the view, you have to really stick your pictures out. So that's what everyone does.
And you have personally observed many people doing that with their cameras?
Yes, and in fact, my family, when they visit, I'm from South America, when everybody visits friends, everybody, that's the first thing they do is stick their cameras out the window, out there. It's not a window, it's just an opening in the stonework.
And the pictures that these folks are taking are towards the proposed site.
In that area?
Objection. This goes way beyond my direct or my
I'll,
cross-examination.
continue.
They take pictures from all different 4 openings, not just that one.
Leave Chrome.
But I should say though, I should add that because I'm the whole golf course owner, especially when I bring people to the monument, which is one of my first stop that I tell them to visit, and I bring them in, they make sure to take photographs of the golf course and the view, because those are the people I'm bringing them and they want to document that. So that specific opening is more popular when they're being brought in by my husband.
And when people take photographs on your golf course, do you ever have weddings there where they take weddings?
Yeah, we do. We have lots of weddings.
And I think there's one in the record of a beautiful bride from the rear with her veil showing. And so, do you believe that that view is really important to your business?
Yes, it is very
Objection.
important.
This is beyond, I asked questions
I
about.
understand, you want to stick to the pictures that are here.
Yep. Will do. Thank you. Sorry. Last is page 7, or not last, but page 7, Lee Crone.
Mhm.
A view from Southern Vermont College. Have you ever been to a location at Southern Vermont College to observe the view yourself?
Yes, I have.
Okay. And are you able to indicate whether this, to your recollection, is a fair and accurate representation of views from Southern Vermont College that you've observed?
I would imagine that this is taken from their hiking trail, not necessarily from just from looking at it. I wouldn't say that it's taken from the actual mansion, from the Everett mansion, but from their hiking trail, but just based on the angle. But I don't know exactly where, but that's what I would say.
And those are public trails?
Yes, these are the public trails. They're very popular in town.
Page 8, John Davis photography. This is 2 pictures from Southern Vermont orchards.
Mm-hmm.
Are those familiar views to you? Have you been up to Southern Vermont orchards?
Yes.
Okay, and to your recollection, have you observed views that are fairly and accurately represented by these photographs?
Yes.
And then page 9 from the Apple Barn, Southern Vermont Orchards website. Is this a view that you remember seeing? Well, have you been up to the Southern Vermont Orchard?
Yes, yes. And I mentioned before, this was our last stop in our site visit that we did with the developer. I don't know exactly from what point this was taken, but
You recognize the land masses and the roads and so forth.
yeah, yeah.
And then next one is page 10, view from Southern Vermont College from the BenningtonHomes.com website.
Mm-hmm.
Was that a familiar view to you, recorded view from Southern Vermont College?
Yeah, and this is on somebody's website. I think this is a realtor's website.
And is this a fair and accurate representation from the college?
Yeah.
Page 11, we're almost done. Southern Vermont College. Tell us where this is from? If you know.
I think this is from, there's a development right on West Road called Colgate Heights. And it's, if you're familiar with Camelot Village it's to the right of Camelot Village, and I believe this is to their higher point from that development.
So this is looking from across town from where we were talking about the college was, is that right?
The back row ramblers image
Yeah.
that you're referring to. This is from, it's not where Southern Vermont College is. It's from, actually, this could be from the hiking trail too. Now that I see that building, it says there actually, Southern Vermont Bennington. I'm trying to see if that is one of their dorms. I can. Yeah, this is from Southern Vermont. I'm sorry. I thought this was from the Colgate Heights, but it's not.
And then we have page 12. Looks like a Facebook post.
Yes.
And this is, I guess, a picture thanking you and talking about the golf course being beautiful. Is that right?
Yeah, and that was something somebody posted. Their kid just had taken a golf camp, and this was the next day. She took her son to play golf, and she posted that. She tagged me on her post.
So you're quite familiar with this location, I assume.
Yeah, this was right from our, right before it's right above the patio. Where is this? No, actually, no, this is not from the patio. This is from hole number 10, from the fairway on number 10.
At like the 100-yard marker?
Yeah, right there, 150, yeah, 150.
150 is right, okay.
Yeah.
And then, so are we seeing?
And that was taken from her iPhone. I could just see her doing her selfie then, right?
And this is a fair and accurate representation from the golf course, from that hole in the fairway?
Yes.
Okay, and are we
Yes.
looking at, to the right of the little boy's club, in between the golf club that he's holding in the air and the trees?
Mhm.
That where we see the road, is that the area where the solar array would be just to the right of that in the?
Correct.
And lastly, we already did your sons, I think we covered all of those. What was the purpose of providing these views that you testified are fair and accurate representations of these various vantage points?
Sure. I mean, as a business owner and as an artist, my biggest issue with this project is that
I'm going to object. I did not ask any cross-examination on her testimony. I asked questions to authenticate the photographs, whether she had personal knowledge about how they were prepared, and that was the scope of my cross-examination, and the redirect should be limited to that.
It's fine, I'll move on.
Do you have any further questions?
Yeah, I just have a couple others. Let's get to.
you want this back. Okay. You want this one.
So Maru, I wanted to ask you about exhibit cross number 4, which are the 3 photographs. We already established the bottom one is the same picture as cross number 2 that we have upside down there. And then we also discussed how you created that, because that's the question that you were being asked. That's from the panorama view.
Correct.
Of the gentleman who took the picture from the Bennington
Monument.
Monument.
Correct.
Okay. So what is it that you created on these top 2, and tell us how you went about that?
Sure.
Explain what those are.
And again, I'm not.
This is way beyond the scope of the redirect or the cross-examination that I did. I did not ask any questions about a simulation that has not been entered into evidence. I did not ask this witness any questions on these, and it's not appropriate for her to be entering that or even questioning a witness beyond that scope.
She absolutely did. She opened the door wide. She asked how these simulations were created. She said, what did you do? You isolated this. You enlarged it, zoomed it, whatever she said. I wrote that down. We can go back in the record if need be. But the simulations were asked how they were created?
Well, she asked about the photo. I don't know if she asked about the simulation.
I absolutely did not ask about any simulations. I asked about a photograph that was in the exhibit at page 6, which has a cropped photograph in it. That's what I asked about. I did not ask about these simulations.
I wrote down the word simulation, and she said that, and she asked how was it created, and the witness responded to that information.
I was,
And
Okay,
she
okay,
testified
let's
about
just
it.
check the record and verify, because the discussion of, I mean, I remember that being up, but it was more about the photo that's in the record, not about this photo, these photos that are not in the record. It's my recollection.
I did not ask any questions about this, what's been marked as Exhibit 4. I was only asking about what's on page 6.
Okay, can we do somehow a search of the record to determine if she asked about the simulation?
I think, and just to clarify, Mr. Wilson reminds me, what happened was when I was asking about this question at that point, the simulation was brought up by counsel.
I asked for it. I said,
Yes.
I can, if I could please have that exhibit to show what I did by pulling in to this image and closing in. So I asked for it.
I did not ask about a simulation.
The quickest way to search is to actually shut down and then reopen the file and search for the word simulation. If you want me to do that, or do you want me to?
Well,
You know,
We'll just withdraw the question. We don't
Yeah.
need to go to that effort. Thank you, I appreciate it.
do you have any further questions on Rita?
Anything else I forgot to ask you that you want to tell the
As long as it's within the scope of what she asked you about.
I think there's a common thread on all the questions that you asked me about the photographers, which was like, how do they take their pictures? What equipment they take? I would like to say that as an artist, I don't question how they do their work. This is the subject matter is a key part of how they make a living and how artists that reside in Bennington are, basically supporting themselves. So I feel like the subject matter will change by this proposed project, and it will change forever.
I object. That this is.
I'm going to allow her to finish. And I'll give you
This
the
project will forever change the views of Bennington, and that have been enjoyed not only by the Bennington Monument, which is the most historic, the most visited historic site in the state, with over 34,000 visitors a year that take those pictures when they stick their camera out the window, and also by all these artists that I have very easily documented that sell their photographs in Bennington in many places in forms of postcards, note cards, bookmarks, and it is alarming to see that this view also from our country club, which is over 100 years old, will be forever changed and with a project that goes against our town plan.
Thank you, Ms.
Thank you.
Mr. Wilson?
Your Honor, is it possible to pick up tomorrow morning with Mr. Wilson?
I don't know how that's going to happen if we have a limited day. We start at 9. We start at 9.
It's David Raphael, so witness.
David, and we've reserved, together there's 4 hours of cross-examination that's been estimated.
I think we need to go now.
Where do we leave this? Are they asking for 3 hours of cross for David Raphael?
Yes.
3.5 hours.
Oh, good.
Would you like me to have the witness say his name?
Yes, please.
Good afternoon. Can you please state your full name for the record?
Bradley John Wilson.
What is your occupation?
I'm a project developer with Ecos Energy.
Mr. Wilson, if you could raise your right hand. Tell me whether or not you swear or affirm under penalty of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth.
I swear.
The witness is free to be cross-examined. Sorry, I'm looking for my big white binder.
There it is.
Mr. Wilson, why did you put excerpts of Rob Wilmington's conversations at the select board meetings into your pre-filed testimony?
I believe you're referring to excerpts from exhibit, I just want to make sure I'm correct here, CS-BW-12. I think the testimony speaks for itself as far as how we're using it, but I suppose in general, we're using statements made by the town about solar project design, solar project siting, solar project location as it relates to the town plan.
How is a conversation between, is this on? Okay.
How is a conversation between the town's attorney and the select board testimony of the town?
I don't believe anywhere in my testimony do I claim it is testimony of the town.
You just said that.
I absolutely did not say that. I think again, I think the exhibit stands for itself. It's clear what it is, what it contains. It's a transcript of a select board meeting where the Bennington Town Select Board made some very specific decisions as it relates to solar project siting and their own town plan.
It's not the position of the town. It's some lawyer telling them what may or may not be his opinion based on any number of factors, issues, realities, costs, benefits, risk analysis, correct?
I don't think I would agree with that necessarily, but again, I'm not claiming to speak for the town.
Well,
This is a transcript of a public meeting that happened, and it's entered into the record for consideration by the commission.
was Mr. Wilmington put under oath?
Not that I'm aware of.
Well, then why would we put his testimony into this proceeding when everybody else who speaks has to be sworn and has to take an oath to tell the truth?
I'm not claiming it's his testimony by Mr. Wilmington. It's a transcript of comments that he and the other select board members made in a public meeting.
Well, that would have been one thing to just put it in as an
I'm going to
exhibit.
object. This testimony is in the record. I don't know where this line of questioning is going. We've been debating this issue of...
I recognize that this is not an objection to the admissibility of the testimony. It's an attempt to characterize and understand the nature of the testimony so that the commission can give it the appropriate weight. I will make two comments. One, Mr. Wilson, you want to make sure that you're answering the question that's asked, not the one that you wish she had asked. And Ms. Dingledine, I want to make sure, just to caution you again, not to interrupt the witness when he's talking. You haven't done that yet. I just know that it may happen here given the nature of the questions and where they're going. But you may proceed. The objections are ruled.
You testified on page 2 of your pre-filed direct testimony of November 27th, 2017. That the amended design of this project, meaning from the first time you tried to get a permit that was denied, now this is an amended application, is that what you're talking about? The amended design, you've redesigned the project from before?
I'm not sure I exactly understand the question, but I'll make my best attempt. The site design that is under consideration in this docket is a revised version of the site design that was under consideration in docket 8302.
Okay. You said that it reduces the project's footprint and clearing area compared to the original design in docket 8302. Tell me what the difference between the cleared area and the footprint is.
Absolutely. The cleared area is the area of existing vegetation on the project site that will be cleared for the purposes of this project's construction. When we talk about the project's footprint, we're talking about the project itself. In this case, that's defined as the perimeter of the, check. It's either the fence or the solar array, and I want to make sure I get you the right answer. Let me check something very quickly for you.
Thank you.
Yes, that's defined as the area within the project fence.
The footprint, that's what you're calling it?
Correct.
And what is that acreage?
7.1 acres.
And then what is the total amount of the cleared area now?
The total cleared area for this project is proposed, I believe the number is 9.64 acres.
I was right on that. We didn't get confused on that. Does that include any road or driveway or traveled way in or out?
That does include the access road to the project, yes.
Okay. So the access road to the project, what road are we talking about that will be used, or let me rephrase that. Tell me any roads that are being used in conjunction with construction or maintenance of this project.
The way I heard the question, it seems a little bit broad. Let me answer and see if it's what you're looking for. The project site is accessible by a single public road, Willow Road. As far as any road that might be used in conjunction with the project, I couldn't possibly define that. But Willow Road is the public road that has frontage to this property.
Well, I mean, I don't mean like, I-89 or, what I was talking about is to access the site. Is the only ingress and egress to the project site Willow Road?
That's correct.
Okay. So I understand that there is property owned by the petitioner that is called the Orchard Lot.
I'm familiar with that, yes.
Okay, and the Orchard Lot, I think the deed is in evidence about restrictions on that lot because it's part of the homeowners association. Is that correct?
I apologize. I didn't hear the question because I got sidetracked. I'd like to add to my previous answer about the Orchard Lot. That Orchard Lot is not owned by the petitioner, but I'm familiar with the lot you're referring to.
Who's it owned by?
A company called PLH LLC. The petitioner is Chelsea Solar LLC.
Okay, so who's this, what was it again,
PLH LLC. And it is a company under indirect common ownership with the petitioner, but it is not the same company as the petitioner.
But it's fair to say that then that lot is owned or controlled by the petitioner or not?
No, the petitioner is Chelsea Solar LLC, and currently Chelsea Solar LLC has no rights or control over the Orchard Lot.
Who owns Chelsea Solar LLC?
I can't speak to the exact ownership structure of Chelsea LLC. I'm not fully aware of that.
You don't know who the members of the LLC are?
I don't know exactly how the company is structured, no.
Are they a Vermont LLC, or are they incorporated or a limited liability company under some other state's laws?
I don't know the exact specifics of where Chelsea Solar LLC was incorporated.
Is it fair to say that Thomas or Michael Malone are involved in the ownership of Chelsea Solar LLC?
Again, I work with both of those gentlemen on a regular basis. I don't know the specifics of how Chelsea Solar LLC ownership is structured in the company formation documents. I do not know.
Well, who do you take your orders from?
My boss at Ecos Energy is a gentleman named Chris Little.
Okay, and your company has been hired by Chelsea Solar LLC?
Our company offers services to Chelsea Solar LLC. Ecos Energy is also under indirect common ownership with Chelsea Solar LLC.
Okay, and this PLH LLC, is that also owned by the Malones?
I just want to be careful because I do not know the exact specifics of how those companies are structured. You speak about the Malones. I don't know if one or both of them are perhaps, I don't know. I do not know how these companies are structured.
Who pays the bills for you to be working on this case?
Who pays the bills? We pay our bills.
So do you have a financial interest in this project?
Me personally?
Yes, you personally.
No.
About a company that you work for?
Well, yes, it's a project we are working on developing.
When I say financial interest, I'm talking about some kind of ownership of the company, shareholder, member of an LLC. Not we're hired by the owners to do a job and we get paid, for the bills that we send them.
Ecos Energy LLC, the entity, does not have any sort of ownership stake in the project. I want to be mindful of time. I do not know the specifics of how Chelsea Solar LLC, Ecos Energy LLC, PLH LLC are structured. I do know that they ultimately flow up into the same ownership structure, and I can say with certainty that Thomas Malone is involved. I don't particularly know if Michael's name is involved in the ownership structure of these companies or not.
Okay, so to your knowledge, does Thomas Malone...
I'm going to object. I don't see the relevance of these questions to the testimony that's been offered by this witness, which relates to the project and its impacts. I see no relevance to and this witness has already asked and has been asked and answered the same question probably 5 times about ownership structure, and he does not know the details of it. He said that.
Is that a response?
Yes. This is the gentleman that I understand has put into evidence the reclamation plan and all the documents that show all the blanks about who needs to be responsible and who would be, there are questions like creditworthiness, the assignment of the project ownership, and or reclamation obligation. In those documents talks about that the assignment of this, and the GMP's agreement, how the assignment of that contract, or if the project were sold to another entity, it would have to be to another entity of equal financial, I've forgotten what the name is, but like rating, viability from a financial perspective. And I think that we're entitled to know who this company is and who's running it, and
This is outside, this is not a Section 203 company. It's not regulated as a Section 203 company like Blue Mountain Power is. This is a Section 248 proceeding, not a certificate of public good proceeding for a company, which is actually called something other than a certificate of public good. But this proceeding is not about Section 203 of Title 30. Those kind of questions are asked about companies that want to form or do business in the state. FERPA preempts regulation of these companies, and they're not regulated by Section 203 of Title 30. So these questions are all outside of the scope.
I just want to know, how does this line of question relate to the document that has to be created to either approve or deny the project?
because I'm trying to understand, I mean, we just got a simple answer that I'm sorry this is taking so long, but I didn't anticipate this was gonna be some hide the ball kind of response.
I think I'm going to ask you, he's given you, I believe, a straight answer indicating what he knows and indicating what he doesn't know, with some clarity.
So are we entitled to ask Mr. Malone questions about the?
He's not a witness.
I know, but if they.
He didn't provide any testimony. I'll allow you 2 more questions.
And I just want to point out the decommissioning rule requires that the financial assurance, it's very specific, it's got to be provided by an A-rated financial
No,
institution.
I understand that.
And so all of these questions are irrelevant because the financial assurance that stands behind that letter of credit for this project is what matters. The rule already takes care of that.
I understand. I'm going to let her ask 2 more questions, and if I see no relevance, then I'll sustain the objection.
Would you agree to a condition of the CPG that the orchard lot is not to be used for any purposes whatsoever related to this commercial project, including traversing roads, rights of way, or planting trees for screening, because it is not the project parcel?
That's not something I can agree to immediately. I certainly think it's something that the petitioner could consider. I'm not in a position to unilaterally agree to conditions here on the stand. I will say that the visual mitigation plan that has been presented in this case does show, and it's been very clear that the orchard parcel is not proposed for any form of access to the project site. But there is some landscaping mitigation that has been proposed with the view of an adjacent landowner in mind.
On the apple orchard lot?
On the orchard parcel, correct. If that landowner has different preferences regarding the installation of that mitigation on the orchard parcel, we're absolutely willing to entertain that and be flexible with where that mitigation is planted, or if that mitigation is planted at all. We reached out to that landowner a number of times to try to get her input on what her preferences would be.
Let's not
I'd like to finish my answer, please. She did not respond to us. So the mitigation that's proposed on the orchard parcel is our best attempt to do something that would be beneficial for her viewpoint. But again, if I hear you asking, would we consider a scenario where we did not plant that mitigation? I think that's something we would consider with the correct stakeholder input.
Okay, but something you would consider. You have just testified that you don't even know who owns that land, and that it has nothing to do with the company that is here trying to get a CPG. So why is this project, why does it have part of the project being proposed for property that is not part of the project site, owned by somebody else, we don't know who, and gee whiz, we won't tell you either?
I disagree with your characterization of what I said. I did not say we have no idea who owns the project site. I said the project site is owned by a company called PLH LLC. I said that I do not know the specific particulars of how that LLC was organized. I have stated clearly that PLH LLC is under indirect common ownership with Chelsea Solar LLC. It's my understanding that the same ownership entity has ownership interest in both of those companies.
And who is that?
Again, I've stated I do not know the exact specifics of how the ownership of those corporations are structured.
But you just said the same ownership entity basically owns both of them. Who's the ownership entity? Who are we talking about?
I do not know how to answer your question, ma'am.
I don't understand why this is a secret. It must be the Malones, correct? Is that your basic understanding?
I
Objection
have,
asked and answered.
Sustained.
I,
Please move on to a different line of questioning.
Are you aware that the orchard lot has deed restrictions that do not allow any commercial aspect related to any commercial project to be sited on that property?
objection, that's beyond the scope of his testimony. There's no development being proposed for the orchard lot in this proceeding. It's irrelevant.
He just said that there are screening, the trees that are
I'm
going
going to
to
overrule
be...
the objection. There is a linkage. You may continue.
I am aware of the language in the deed for the orchard lot. I do not believe the way you characterize it is accurate.
Why not?
I apologize, I do not have the deed handy, but I have read it a number of times. There is, and again, I'm going to be paraphrasing from my own memory, there is discussion in the deed of the orchard lot about a deed restriction against commercial uses. I can't recall your exact wordage, but you extended it when you were describing it about commercial uses or anything linked or related to a commercial use, and the deed does not say that. What has been proposed on the orchard parcel is some landscaping, some shrubs and trees. Again, I'll point out we are very open to working with interested stakeholders on the exact placement of that landscaping if they would like to participate and discuss with us. I do not believe that deed restriction issues really have a place in this type of proceeding. I don't believe that PUC typically considers such issues in their decision making. But I also do not believe that the planting of some bushes and shrubs constitutes a commercial use.
Well, isn't that part of the mitigation that you're proposing for this project?
Okay, I'm going to cut you off because you're asking for evidence that will not be adjudicated by the commission. The commission will not make a determination as to whether or not the planting of trees and shrubs on that property is a commercial use in violation of the deed.
I understand
That
that.
needs to be done by a separate jurisdiction and is irrelevant to this proceeding.
I understand that, Your Honor. However, we have an applicant here who has been involved in serial litigation, multiple cases
Objection,
against
objection,
Bennington, for
objection.
example. And,
Objection.
excuse me, let me
Wait till she
finish.
finishes her question.
I'm trying to
Wait till
prevent
she
her
finishes
from
her
finishing,
question,
actually,
please.
because she's making very malicious, derogatory statements
Well, you
about
can make
my
that
client.
objection once she finishes.
That they're involved in litigation against
Serial
Bennington?
litigation, it's
Absolutely.
completely
Mr. Malone told
Okay, enough.
Mr. Malone told me the other day, he
I-
is in...
Please let her ask her question. Then you may make an objection.
Mr. Malone told me the other day, no, I'm discussing this.
This is,
with
again, I'll
the
remind
hearing
counsel
officer.
that the statements of counsel are not evidence, only the statements of witnesses.
I understand,
proceed.
I understand, thank you. That he is involved in suing Green Mountain Power in federal court.
Is there a question here?
I'm trying to explain to you.
I want you to ask the question so that I can hear it.
Okay.
I don't know what question you're asking.
I was interrupted by opposing counsel when I was in the middle
Right,
of
and I want
trying
to give
to
you the opportunity to
explain.
ask that question.
But I was trying to explain to you why I was trying to elicit this information. It has nothing to do with having...
I don't know what the information is. I did not hear a question. Please ask the question again.
All right, so this, I don't have a question. I need to respond to you. You've said to me that I am not, that the commission is not going to worry about deed restrictions, and I understand that you're not going to adjudicate that issue. The reason why I am trying to gather information from this gentleman, and he has just made the point that he doesn't think that this has anything to do with anything, but in fact, if this screening, which is under the jurisdiction, and people checking it for years and making sure it is or isn't good, and it has to be replanted, and it is part of this project, that is a commercial use. And the reason why,
Well,
and
I'm not sure that
regardless,
the commission will make that jurisdiction
and I'm not
determination,
asking them to.
and I've stated that to you.
I'm not asking them to, but the reason why I am trying to get some information at this point is because the commission needs to understand, based on the litigious nature and the threats of litigation that have been involved in this very proceeding, including on this very issue with the homeowners association, being told, well, you know what, go over to Superior Court and bring a declaratory ruling. If the commission does not appreciate and understand that those plantings and the involvement of this lot will put the homeowners association in a position to have to litigate it in order to enforce their rights, then
The commission is aware of that. You don't have jurisdiction. If you want to resolve that, it has to be done elsewhere.
But the applicant, it's like, apparently the applicant and the orchard owner is the same person, or people. So, the problem being that the Malones are the ones who get the homeowners' notices sent to them, so we know.
You're making a cut the corporate veil argument. It would be more appropriate in a different court.
For people who can't afford to go to court. And all I'm asking is that the commission have a little bit of information so that they know.
The commission understands that the Apple Hill Homeowners Association has a claim that this deviates from the deed, and they're aware of that. It's in evidence.
And it's been ruled on, actually, that it's beyond the commission's jurisdiction.
That's correct.
But it doesn't mean that they can't use that information in the calculus when they analyze and decide whether or not they're going to give it CPG.
Absolutely, and that's why it's in the proposal for decision that's been presented in Apple Hill. And for the same reason it would be in this proposal for decision, so that it can be considered in making that kind of determination. However, they will not make a ruling about it.
Okay, thank you. So, there is no plan to use any road over the orchard lot, correct?
That's correct. There is no plan to build a road over the orchard lot.
And what about driving over the lot to get to the project site?
There's no plan to drive over the orchard lot to get to the project site.
What road, and I'm sorry if this is a little off kilter, but I don't know enough about the roads and all, but Apple Hill, that's being accessed by a different road, not Willow Road, is that right?
You're talking about the Apple Hill Solar Project?
Right.
The proposal is for the Apple Hill Solar Project, and that's a different docket, but that would have a private access driveway coming off of Willow Road.
The Willow Road will be used for both projects.
I would say Chelsea and Apple Hill both have private access driveways that connect to Willow Road.
Willow Road is public?
Willow Road is a public road, correct.
So you're gonna build 2 access driveways off of Willow Road or 1?
Well, again, I don't want to conflate the projects. There will be an access road for the Apple Hill project, assuming both projects proceed. There will be an access driveway for Apple Hill off of Willow Road. There will be a second separate access driveway off of Willow Road for the Chelsea project.
And they are separate driveways that come off of Willow Road in different locations, correct?
That's correct.
Okay, thank you. Fencing height on this, around the array has been increased to 10 feet. What was it before?
In the original proposal, in docket 8302, I believe the fencing height was described as 8 feet in height.
Okay. How tall are the tops of the arrays on the ground?
I can find the exact number if you want me to spend a minute hunting, but it's approximately 8 feet in height from average ground surface to the top of the highest solar module.
Can you indicate where this mesh fabric stuff is going to be placed on that fence?
I think Mr. Busher earlier really accurately described the way that mesh screening is called out in both his testimony and my testimony. Again, I can find the exact location, but it's described as being installed in certain locations. And the way Mr. Busher described how those locations would be determined is entirely accurate. Board Rule 5.800 is in play. Typically, there is a post-construction site visit related to mitigation. And what we would propose in this case, and thank you for the opportunity to explain it in more detail, because the site is wooded, I think it can be difficult prior to clearing to have a perfect understanding of exactly where any thin spots in the retained vegetation might be. And so in this instance, I think we envision, and I believe this is one thing that made it in to our agreement with the town, is that post clearing, the site would be evaluated with hopefully with stakeholder input to determine where that screening could be installed that it would be a benefit, and to avoid locations where stakeholders believe it would be a detriment.
The site after the trees are removed, is it going to be all mulch or is there going to be grass planted?
Both. During the clearing itself, the wooded material that would be cut down would be chipped and spread on site. But grass will also be planted following project construction.
So is topsoil going to be put on top of that chipped wood stuff?
No, typically the woody material will mix with the soil we anticipate. This is based upon other projects we've built. In fact, one particularly recently. During construction, the chip material does mix with the soil pretty well, and you can come in and put hydro seed after the project is built and have a nice green vegetated ground cover.
Are you talking about that stuff you have a hose and it's like greens and there's seed in it? Is that what you were talking about?
That's one form of hydro seed. Yeah, it's a mix that has, in addition to the seed itself, provides initial hydration for that seed to germinate and take root.
Is that part of the mitigation or landscaping plan?
My testimony does describe that the project will be seeded after construction.
Is there any, pardon, is there any representation about the actual area that seed will be planted? Is it the entire location that is going to be cleared? Or?
I don't recall if my testimony specifically calls that out, but I'm willing to state here that yes, the intention would be to seed the entire cleared area, with the exception of locations such as the driveway or the equipment pad, for example, obviously.
And then how would the area be kept mowed or whatever? Is that?
Yeah. Periodically during the the growing season, we would go in and mow it, have it mowed mechanically.
How often?
It all depends on rainfall, growth rate, but I would say on average, we typically see once every 5-6 weeks or so, go in and have something mowed.
And does the fact that your solar panels are fairly flat, not vertical, have an impact on maintenance of the site in terms of keeping the grass mowed or something like that?
Not especially. The tilt angle is 15 degrees, as I think you're referring to, but the racking system is designed for there to be at least, approximately 36 inches of ground clearance between the ground and the lowest point of the solar modules. So that provides a significant amount of space to access for mowing equipment.
On page 7 of your testimony, towards the bottom of the page, line 18, you were talking about vehicles and equipments associated with the clearing work. Will access the site via the vehicle access driveway off of Willow Road. Then you say vehicle traffic could vary from day to day, but may reach up to a maximum of 6 heavy trucks and 30 passenger vehicles to and from the site per day. How many people are you have working at this site that you need 30 trips to and from in passenger vehicles?
There might be some confusion about how those numbers are used. They're intended to be the number of trips. I would never anticipate there would be 30 different people working on the site at a time, although that I can't give an exact number because that kind of depends on the contractor we hire and how they plan to proceed. But these are estimates, and I should also point out that this is a maximum amount, and the next sentence says average traffic per day over the course of the clearing phase would likely be substantially less than this.
Yeah, I thought that was kind of interesting because you say substantially less than the average. So what does that mean? You're going to have days where there's like masses of people and trips coming and going, and others where nobody is to get that average?
Sure. I didn't say substantially less than the average. I said substantially less than the estimated maximum. Your average day is going to be substantially less than a estimated maximum. Again, if I imagine a day during the clearing phase, typical operations just based upon my own experience, you might have 5 or 6 guys on site at a time, and that would be the extent of the vehicle traffic to and from the site that day. That might be a typical average day. But especially at the beginning of the clearing phase, when you're making the first cuts into the site and you're trying to get the first portion of the driveway installed concurrently, the clearing equipment itself is being delivered, you might have a spike of traffic for a couple days right at first, and that's why I tried to estimate the maximum anticipated daily traffic that could be experienced, but also mentioned that your average day is likely to be substantially less than that.
But yet, when you get to the construction work, on the next page, page 8, around line 18, you didn't use the word substantially less, you just said would be less than that, when you were talking about the average versus the maximum. On 18, you say maximum of 4 heavy trucks and 40 passenger vehicles to and from the site per day. Average traffic per day over the course of the construction phase would be less than this, not substantially less.
Right. You're correct that the word substantially is not included in that line. During construction, we would have likely more employees on site working than during the clearing phase. If you have the solar modules getting installed, for example, there might be a crew of 10 individuals working in tandem to install the racking and then come along behind them with solar modules. So again, I tried to provide a estimated maximum daily traffic number and then followed it up saying, but still, on average, your average day is going to be less than the estimated maximum.
And more than the estimated minimum, though you didn't estimate that.
I did not provide estimated minimums, no. I mean, I think that would probably be 0.
So let me ask you about these hours and how many months. It looks like 3 to 6 months is the combined amount of time for clearing versus construction. Is that about right?
Those are estimates, but yes, I believe that's what the testimony reflects.
That seems like an awful broad difference. If, you know, your company has been involved in so many of these projects, why would there be such a wide divergence of, you know, the amount of time that would be necessary to clear and then construct a certain amount of acreage?
Well, that's a great question. Construction on this scale is subject to a number of variables that are entirely outside of our control, weather being primarily one of them. Equipment delivery schedules, when materials are available, availability of labor. You could build a project in 3 months with one contractor that takes a different contractor 6 months, depending on the amount of employees they put on the site at any given time. The estimates that I include in my testimony are based upon my own experience managing construction of exactly these kind of projects over the last 8 years.
In terms of the people you're hiring for the clearing and construction, are those local jobs, or do you bring in people from out of state?
We have not identified a contractor for this job and would not at this point in the development process.
On page 9, so I guess you can't represent that there would be a benefit to the state of Vermont by creating jobs, at least for temporary jobs, based on what you just testified to?
Nowhere in my testimony does it guarantee that employees working on construction would be local Vermont employees. I'd say it's likely, but I can certainly make no guarantees. I would not, the way you worded that, I just want to make clear, I can make arguments that this project provides benefits to the state of Vermont, just not specifically in the topic you're discussing now.
Yeah, that's fair. That's all I was getting at. And how many projects has your company been involved in to clear cut or to construct these kinds of facilities?
I'm going to look something up so I can give you an exact number.
Of those 23, how many of those projects did you hire Vermont workers to fill
Objection.
at least 50% of the jobs?
Objection. 248B4 is not even, which is the economic benefit criterion, is not applicable in this proceeding. The witness has not offered testimony on economic benefit in this proceeding, and the question is beyond the scope of anything that's provided in his testimony.
This pertains to the traffic that will be related to this project, as to where these folks would be coming from, and if they are coming from out of state, because that's the rule rather than the exception. I'm just curious to know what the composition of these workers are.
I think he's already answered that you're asking about other projects. He's already answered your question as to this project. They haven't been retained yet, so how would he know? He doesn't know. He's already said that.
I understand.
Are you concerned about the impact of Vermont roads by out-of-state people?
Well, there are myriad of issues that it relates to, greenhouse gas emissions. Pardon me?
Given the numbers of employees that he estimates here, you have that concern?
I'm not sure how many employees there are going to be. I was unclear on that.
He does give an estimate of, we just go through the whole potential maximum and approximate minimum, or approximate average?
Well, for trips, but I don't know how many people are going to be in the car.
Well, why is this relevant?
relevant to other issues.
Such as?
We'll come back to it later. I'll move on to something else. I'm going to talk to you about water usage. You testified on page 9, lines 18, 19, something like that. Washing of the solar modules is not anticipated in the Vermont environment. But if module washing is needed, that would be performed with only water, no solvents, that is trucked in from off-site. So, which is it? Is it needed or is it not needed? Based on your 23 other projects that you have been involved in.
Right. This is one I think the testimony does speak very clearly, and you just read it to me. I don't want to be duplicative. Washing of the modules is not anticipated in the Vermont environment. We have another operating project in Vermont. We've never had to do module washing there. We've also got operating projects in Connecticut and Massachusetts, which are close enough to be proximal, and we've never had to do module washing there. The reason for that is that the snow cover we get in the winter, as it collects on the modules and then slides down the module face as it melts, does a great job of cleaning the surface of those modules. In other environments, manual module washing is needed, such as California, more southern locations, or locations located directly next to active agricultural operations, things of that nature. So I would say, no, we do not anticipate, based upon our experience, module washing would be required for this project. I do not want to preclude the possibility that we may at some point in the future decide, hey, we would like to have the option of scrubbing these modules if needed.
How much water is needed to clean and wash solar panels that comprise the size of this particular project?
I don't know the answer to that question.
How many solar panels are there now that you've squished them together and gone up in their productivity?
I don't know the exact quantity, but I believe for the Chelsea project in its current configuration is around 7,000 individual solar modules.
Why didn't you do any modeling on the construction noise?
I'm not a noise analyst.
Well, why didn't you? Okay, let me rephrase. So RSG did sound studies to prove that there's no undue adverse impact regarding noise. And they said, well, nobody gave us any rebuttal testimony, so we weren't asked to do anything else about the construction phase, even cutting with chainsaws or digging with excavators, trucks, bulldozers, blah, blah, blah. Why, I assume you're sort of the guy in charge of this project, why would you ignore that impact to the surrounding landowners without having modeled that, taken readings or used information from other sites and modeled it according to the project site that is at issue here?
I certainly don't believe it's accurate to state that we have ignored the question of construction noise, or noise generated during the construction phase. I think the detailed description given in my testimony of the construction activities that will be taking place on site paint a very clear picture of the type of equipment that would be used. We also very clearly define the days in the week and the hours of operation where that equipment will be used. And based upon typical evidence entered into other cases like this, I think that gives a sense of a temporary, typical construction impact. You're correct. We did not ask RSG to do a technical acoustic modeling exercise regarding construction noise. I think we typically, when deciding what evidence to ask our witnesses to prepare, we obviously have a vested interest in making sure the docket contains all the information that the commission might want to look at. We take a look at other projects that have gone through the process recently and been approved. Take a look at the commission's orders in these projects and what evidence they're seeking, what evidence they're saying was missing or not. And based upon that, a model, technical acoustic model of construction noise was not something that occurred to us to perform. Furthermore, in each individual case is different. We often rely on input and questioning from other stakeholders involved in the process. And this is the first time I'm hearing that any of the parties have had an interest in construction noise. If any of the parties had brought that forward earlier in the case, perhaps that is something we would have pursued. To clarify something Mr. Hawk said earlier, we filed our original evidence in November 2017. The other parties, I believe, filed their pre-filed testimony in June 2018. The evidence filed by your clients did not contain, any questions or evidence regarding construction noise. And so when we prepared Mr. Hawk's rebuttal testimony to your client's pre-filed testimony, construction noise was not a topic we had in mind at that time.
Laura Block's pre-filed testimony did not contain information regarding concerns expressed about construction noise.
I can pull it up right here if you'd like me to take a closer look.
Stockpiled soils. Where, referring on to stockpiled soils. I think that was on the pre-filed testimony of Laura Block, June 22nd, 2018. The question number 10 in her pre-filed is, as a resident of Apple Hill who has experienced an increase in traffic noise after the construction of Route 279, and having read the pre-filed testimony in this case, what is your opinion of the noise study commissioned by the petitioner? And her answer on line 1 of page 4 is, the study shows that noise in Apple Hill will increase if the forest is cut, but the claim is that it will not be by very much. We believe that study is inadequate. The Route 279 interchange has already increased our traffic noise, especially from trucks, and it will be made worse by clear cutting for the solar project, which is not acceptable. Our neighborhood should not be required to deal with yet more traffic noise. Hold on. Anyway, she's going to look further, so I'll come back to that issue.
This was a while ago. Sorry.
Stockpiled soils. The construction of this project, you are digging into the soil and having to remove soil and then pour concrete for footings, or how is that going to happen?
No, not at all. No concrete footings are proposed for the solar racks themselves. There is a limited size concrete equipment pad that's described in my testimony. The footprint of that probably approximately 10 by 20, and that's the only concrete foundation proposed for this project. But concrete footings are not proposed for the racks themselves.
Okay, but where does the stockpiled soils come in?
I'm not familiar with any stockpiled soils that are proposed for this site.
Well, you said in your testimony about the decommissioning phase, which is on page 10 of your pre-filed direct. You said decommissioning involves the removal of project equipment from the site, restoration of any stockpiled soils, revegetation and restoration of the project site to a natural state. Right. You tell me that's just some general statement that you made that's not applicable to this project?
Well, so let me start by saying this This is my original pre-filed testimony in this case, filed with petition to begin this docket. The statement says any stockpiled soils on the site would be restored. If there aren't any, then there are none to be restored. When we filed this petition, prepared this language here, we did not yet know whether or not the Agency of Agriculture was going to participate in this docket. They had in previous dockets and have requested the addition of conditions that require stockpiling of certain soils. Having been through that a number of times and not knowing what that agency would do in this case, I believe this language wanted to leave the door open in case such a condition came about. It did not.
Okay, thanks.
Mhm.
And the other thing I want to ask you about is underground, this is on line 17, underground conduits, wiring, and foundation posts will be cut off at a depth of 24 inches below ground surface level and backfilled. So that means that you're leaving electrical wires in the ground?
No, that's not correct. That is what the testimony says here, but after the filing of this testimony, we received a communication from either the hearing officer or the commission reminding us that such a requirement is not compliant with the PUC's current rules regarding decommissioning plans. So a revised decommissioning plan was filed shortly thereafter, I believe on December 4th.
Gotcha, yeah, because I saw it in the difference there. And then monitoring for invasive species for a period of 1 year. That sounds like that would not be an adequate amount of time to remove and then ensure that invasive species are completely eradicated and are not coming back. Why such a short time period for that?
Well, I'll start by saying I believe that the decommissioning plan on the record is compliant with the PUC rules for decommissioning plans. The project will reach a point at some point in the future where it is decommissioned and no longer exists, and the property at that point ceases to become the solar project site and reverts back to just being a private property owned by a private property owner. And we're saying that for the period of a year, we'll monitor and try to keep invasive species out of there. At some point, though, the obligation of that property owner after the project has been fully decommissioned must, stop being obligated to the conditions of the solar project. That's a particular condition that if that was a really point of concern for any particular party in this proceeding, we would absolutely be open to being flexible on that period of time.
You have also reviewed the dollar amount in terms of the bond or financial obligation on decommissioning. I've forgotten what the amount is, 100 and something thousand. How do you determine that? I saw your little chart, and I understand you were conveying that information in 2017 dollars. But how does one figure out whether, for example, you say, we'll recycle stuff at a nearby recycling facility? What nearby recycling facility in 25 to 40 years? How do you know what the costs are going to be at that point in time?
Right. I think the word estimate is used pretty liberally when describing these numbers. I have no idea where the nearest recycling facility will be in 40 years. There's obviously no way I could know that. We review to come up with these numbers, I reviewed the scope of the project design with 3 different contractors that we've worked with in the past to get their feedback on the amount of labor that would be necessary to perform this work. Using that information, we prepared these numbers that were submitted, and based upon my experience managing construction of these projects, I find them to be reasonable estimates.
Let me move on to page 14, line 17 of your pre-filed direct testimony. Let me move on to page 14, line 17 of your pre-filed direct testimony, wherein you state the town select board held several public meetings on the revised plans, culminating in August 2017 in the select board voting to withdraw its opposition to the Apple Hill Solar Project because, in the words of the town attorney, the revised plans are, quote, consistent with what I see is the text of the town plan. And then you say, see exhibit CS-BW-12 transcript of August 14th, 2017 select board meeting at 38. So, that's not just putting an exhibit in and showing what a discussion was had at a select board meeting. You are making an affirmative representation that the town made a decision and acted, and then you attribute their actions and explain a reason why by quoting part of a discussion that the town's attorney had with the select board. Do you see how that appears disingenuous and, troubling to people? That you would attribute the decision of a select board that are elected officials who are charged with making a decision, and you somehow attribute their reasons to their behavior, which not even a select board member would be competent to explain or testify, because boards act through their votes and their public action of actually making decisions that they vote upon in public session?
No, I don't.
Do you think that's a fair and accurate representation of what Rob Wilmington's conversation means?
Yes.
You think it's appropriate for you as a developer to lift his conversation, albeit in public, and to attribute actions of this board and try to explain it by something that he said among many things that he said during a conversation, to try to explain it that to your benefit as the applicant here?
I don't believe that's what my testimony attempts to do. I was at that meeting in person. I've also reviewed the transcript that is in evidence in this case, and I present the comments that are included in my testimony as facts of the conversation that took place that evening. I also took part in numerous discussions and other meetings leading up to that meeting, and so in the overall context, this is what I believe took place that night. The transcript itself is on the record. It speaks for itself.
Then why didn't you let it speak for itself? Why did you try to take information, little snippets out of how many pages is this conversation? 50? And you tried to take that information where the conversation was an attorney trying to give a town different perspectives, issues, legal concerns, blah, 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 and then who are you to take Mr. Wilmington's conversation and attribute some, motivation or explanation that this is why the board decided to do this? The board is not Rob Wilmington. You don't see that as being problematic? That you, under oath, have made that representation when you have no personal knowledge whatsoever other than sitting in a room and listening to a conversation? Are you inside the heads of these board members?
My participation in that process was much more than just sitting in a room listening to the conversation.
Are you on that board? Were you in an executive session wherein you discussed it with your other board members and then came out of executive session and voted on something? Do you know what was going on in executive session?
No, I'm not a member of the Bennington Select Board.
Okay.
No, I did not participate in any of the Bennington Select Board executive sessions.
Then how dare you
Objection,
attribute this
objection,
to
objection.
the
This is
town?
not a
Sustained.
question.
He's asked and answered that he sees no problem in using the quote that he does. I'm not sure why you want to lecture him on that issue, but I'm going to sustain the objection and ask you to move on to another area. It's 6 o'clock. We've already gone well beyond the initial time. It's already an hour into Mr. Wilson's testimony period, How much more time do you need?
Half an hour.
Proceed.
Well, and then you are taking Bennington Select Board Vice Chair Don Campbell's email to Libby Harris and putting that into your testimony. When she forwarded you that email and said, let's sit down and I'll be happy to sit down with you and talk after having this conversation to settle for settlement discussions. Do you see that as problematic, that somehow you have now taken this information and tried to put it into your testimony as if this is under oath, personal knowledge about, I'm not even sure what, some guy on the Bennington Select Board has an opinion? You think that's proper testimony to put before this tribunal?
You know, I'm not an attorney, I can't speak to what is and is not proper testimony, but
Well, you have an attorney that prepared this document and sent it in, right?
attorneys were involved in reviewing this document, I can't speak to them. No, I don't see it as problematic. That was a statement made by, at the time, party opponent. Project
Right,
opponent.
pursuant to settlement discussions, which, and this is on page 16, line 16, 17, 18.
I disagree with the characterization that that was part of settlement discussions.
Well, when she said, well, I'll sit down and talk with you, that was to work out issues and concerns and try to settle some of the dispute, right?
I'm not going to object. The witness has already answered the question. This exhibit has been in the record. It was never objected to previously. And the characterization that these were Rule 408 settlement discussions, I think, is overstated. I don't know what the point is that is being made here other than to lecture this witness about questions that are really legal questions.
Well, let's hope he doesn't repeat his behavior in the future. So let's move on to okay, on page 31 of your testimony, you said on page, on line, say, start at 8, you were, well, let's start a little sooner than that, 5. Some neighboring residents have raised concerns that the proposed removal of trees on the property, project property might result in an undue adverse increase in vehicle noise that they experience at their homes. The vehicle noise in question is generated by vehicles traveling on Highway Route 7, which is located south and west of the property. In my own words, the vehicle noise in question is not generated by the project or on the project property. And it is not generated by a source that is associated with the project in any way. The vehicle noise in question is not generated by a source that the petitioner has any control over or any responsibility for. Would you agree with me that all of these truck trips, all of these passenger car trips is going to increase the noise, because otherwise these folks would not be there, there wouldn't be any of the construction noise, all of that. So that statement specifically, well, it's really not true because there is traffic noise being generated by the project. Fair to say?
Not fair to say no.
Okay. Okay, then I guess we disagree.
The statement that you read was in regards to the neighbors' concerns over highway noise generated by vehicles traveling on Route 7. It's not related to vehicles traveling to and from the project site. So
are you not, no one's going to go on Route 7 to get to the project site?
I don't know.
Exactly. I'll move on. Oh, maybe you know. What's the slope of this project site inside the footprint area?
It's somewhere between 8 and 9%.
You would agree with me that that's a moderate slope?
I don't know what qualifies as a moderate slope.
Well, I think we had this discussion the last time. I can't remember if it was with you or one of the other witnesses.
It was with Mark.
With Mark, okay. But you take a position this is not a hillside, even though there is a slope of moderate grade.
I don't think I've addressed the topic of whether or not the project site is a hillside in my testimony.
I think you talked it down on page 35, whether the project was sited in a prominently visible location on a hillside, and you said no. First, there's no definition of what a hillside, of what is a hillside, so it is impossible to apply that guideline and create any meaningful development standards, but regardless of the issue of what constitutes a hillside, the project is not sited in a prominent visible location. So your testimony is, what did you say the slope was again?
Somewhere between 8 and 9%.
Okay, so an 8 to 9% slope is not a hillside?
I don't believe I ever said that.
Well, that's the equivalent of what you're saying. You're saying it's not on a hillside because there's no definition of hillside, but you've testified 8 to 9% is the slope here, and so you must be concluding that 8 to 9% is not a hillside.
I completely disagree with your characterization of my testimony. My testimony says, no, the project is not sited in a prominently visible location on a hillside. My testimony makes no judgment as to whether or not the project is sited on a hillside. It does describe that I do not believe that the term hillside is defined anywhere in any town plan or related document. But I'm not speaking as to whether or not I believe that 8 to 9% slope constitutes a hillside, because I do not know what standard would be applied to reach that conclusion.
How about common sense standard?
Sometimes I'm not as familiar with that one as I'd like to be.
Well, you're the one who put in all of these definitions from Merriam-Webster and American Heritage Dictionary, and it says an incline, especially on a road, a slope. 8 to 9% slope is not a slope?
It is a slope. Any incline greater than 0% can be defined as a slope, and I think that's the point of the definitions that are included in my testimony to show that, by standard dictionary definitions, a hillside could really be defined as any piece of land with greater than 0 slope. And then tie that back to a discussion of how the town plan does not include a definition of what constitutes a hillside.
Why did you say that of critical importance, this is on page 37, of critical importance, the bylaw makes it clear that development is not prohibited? What's that got to do with anything? Your other expert, the first fellow, I've forgotten his name, he talked all about how and I think Mark Hayne may have done it, I'm not sure which, but what has the zoning bylaw got to do with anything? He's the one who said no. Mark said no, nothing else applies, it's only the town plan. Yet, you're trying to use the bylaw when it suits your purpose, and yet then you say you don't want to use the bylaw through another witness when it doesn't suit your purpose. See the inconsistency in the presentation that we are dealing with?
No, I don't.
One witness says the bylaw is critically important, and the other says, we don't pay attention to that at all, you don't think that's a conflict in the information that you've given the PUC on this case?
I don't think my testimony says the bylaw is critically important. I say of critical importance, the bylaw makes it clear that development is not prohibited.
Okay, but isn't zoning prohibited under this process here that we're involved in? The bylaws mean nothing because they're preempted. Do you know what preemption means? That they don't apply?
I disagree that they mean nothing. I understand that, again, I'm a layman, I'm not an attorney, but my understanding of the statute is that zoning bylaws should not control the outcome of a 248 proceeding. However, especially in a case such as Bennington, where there is so much intermingling and overlap between the town plan and the land use regulations, I think the land use regulations implement the town plan to a certain extent. And the land use regulations make it clear that's what we can look to see all these other types of uses, including energy generation facilities, that the town's own land use regulations say are allowed in the rural conservation zone. The point here is that the development of many types, including this project, are not prohibited by the town's bylaws in the rural conservation district.
You say you're not a lawyer, you say you're not an expert, but gosh darn, you have a lot of testimony in here that is making all sorts of representations about whether we use bylaws, what your opinion is, whether or not the town plan is intertwined with the zoning
We're going to
ordinances.
be here until 7 o'clock
Excuse me?
tonight if this continues. He's answered the
I'm going to
question.
overrule the objection.
I did.
If I could continue. The interveners have the opportunity through cross-examination to characterize, to limit, to expose the testimony of the petitioner's witnesses so that that testimony is given the appropriate weight. I will note that it is 6:15, and she has 15 minutes left.
You're correct that I'm not an attorney.
There's no question.
There was.
On the bottom of 36, you say on line 17, let me go to line 16. Development shall be blended into the existing natural landscape to minimize its visual impact from public roads and lands. This effect shall be accomplished through one or more of the following: siting of structures within forest or forest edge areas. That is precisely what has been done with this project. It is located within or at the edge of the wooded area. How is it, if you're clear cutting, that it's within a wooded area?
For starters, I would point out that this section of my testimony is a discussion of zoning regulations that we believe do not apply to this proceeding. But the project is being placed within a wooded area. It's being surrounded on almost every direction by hundreds of feet of existing forested vegetation.
I guess it depends on the definition of is. And then you say it is not visible from the Vermont Welcome Center or other public lands or the neighbors. And visibility from public roads and the neighbors is screened. Of critical importance, and then we go into that bylaw thing. No exception, no wiggle room here. You claim that it is not visible from public roads and the neighbors and the Welcome Center, right?
That is what the testimony says.
Okay. Okay, and then on page 41 of 41, you make an argument about this 10-acre rule applying to solar only and no other kind of development in Bennington. It's unconstitutionally discriminatory on its face, but you're not a lawyer, and you've made that accusation in your pre-filed testimony.
I'm going to object
Right.
only because this line of questioning relates to a document that the commission has ruled is not relevant in its vested rights ruling. This is the solar screening ordinance.
I understand, but overrule your objection. Again, this is, this question doesn't have anything to do with the specifics of what's in this paragraph that starts at 4. It's with the interviewer's attempts to characterize the testimony of this witness.
You're correct.
And it goes to the credibility of the witness.
You're correct, I'm not an attorney. This information is based upon my understanding after multiple discussions with other people on our team.
On page, what's this thing? System Impact Study, CSBW-9.
What page?
Page 38, you say in 5.0 cost estimate, a budgetary estimate of the interconnection costs will follow under separate cover. Did you ever provide that?
I don't believe that has been provided in this docket.
When is that going to happen?
I don't think we're planning on entering that information. This is not my language. This is GMP telling us that they will provide us a separate cost estimate under separate cover. This is not me saying that I will provide a separate cost estimate.
Oh, just bouncing back to your rebuttal testimony, August 10th, 2018, page 11 of 44, on line 19. You say the Apple Hill project is proposed as a separate facility on a different portion of the same parcel of land as the Chelsea Solar project. Is that correct? It's all on one parcel?
Give me just a moment to pull up that reference. It's in a different binder.
Well, you don't need to look it up. Are the two projects on the same parcel of land?
Yes.
And that land is owned by whom?
The project site is owned by PLH LLC.
What is the vertical differential between the of the array in terms of the vertical rise or difference in elevation of the lowest point of the array in the front of or closest to the south versus the highest point at the height of the land for the actual solar array?
I don't know the answer to that off the top of my head. I do know that information was provided as one of our discovery responses to the interveners in this case, but I don't have that with me.
Could you look at the exhibit, the 45-day notice materials, exhibit CSBW4? A few pages in, there is some kind of cross-sectional thing that shows the proposed array.
You're talking about sheet C101?
My copy doesn't have any.
Lower right-hand corner.
It's got like these cross sections of green.
Yeah, that's the same sheet I'm looking at.
Okay. It looks to me like the high is at 752 and the low is at 710. Is that right? Something like that?
I would say that is what this document reflects, and that's probably fairly close to what was actually filed. But keep in mind, this is the 45-day plan set and not the project site plans that were actually filed.
Oh, okay. So then, because there's a map in this section that talks about the clearing for the project is 9.8 acres.
You're talking about CSBW2, is that correct?
When I printed these, they didn't all get on the page, I guess. Anyway, we're clear on the amount
Yeah.
that you testified earlier. You're certain of the two amounts of the footprint versus the cleared area?
Correct. The cleared area for this project is 9.64 acres.
And the footprint's 7.1.
That's correct.
Okay. Can you tell me how much of the Chelsea project area, the original Chelsea project area, got added to the new Apple Hill project area? You reduced the Chelsea project to these numbers we just talked about. Apple Hill, it got expanded how? How much?
I don't have the answers to that readily available. I don't have the documentation with me that I would need to reference.
So we have the settlement agreement in evidence, Your Honor? Has that been submitted as an exhibit in this case?
Yes.
It has. Just one moment. In terms of the negotiation that resulted in a settlement agreement and the prior proposal that was made to the town of Bennington, I understand that they were requested, that the petitioner requested not just that the town withdraw from the proceeding and withdraw.
Objection, settlement discussions are not allowed to be in evidence. I don't see the relevance. We have a final stipulation that resulted from settlement agreements.
Well,
Settlement discussions, but the settlement discussions under Rule 408.
the draft was made public though.
You're asking about discussions.
Okay, the prior draft that was submitted to the town, that was discussed in public and circulated, required that the town not just withdraw and not just withdraw Mr. Monk's testimony, but it also required that the town actually take the position that this project complied with the town plan, yet that is not now in the actual settlement agreement. And do you have any knowledge, were you there at the meeting, about why that provision was taken out of the agreement and the town refused to agree to that provision?
I think we're going to tread into territory we were walking on earlier, where I feel like now you're asking me to try to read the minds of the select board members. I did not participate in this round of settlement discussions with the town. But I did observe the meeting that took place when they discussed it publicly and voted on it. I have a personal opinion on why that might be, but I just don't think that it's appropriate for me to say that that's why they did it, because I was not part of those conversations this time around.
Were you there physically at the meeting?
No, I watched the video of the meeting.
Afterwards or in real time?
It was not live streamed. I watched it a day later.
So when you watched it, did you hear any conversation, public conversation about that issue?
I did.
So forget about speculating about why a decision was made. What do you recall hearing about this issue in terms of opposition to taking the position that the town plan is not violated by this and should be supported because it complies with the town plan?
What I observed, discussion on that particular topic, were some of the association neighbor speaking that were very unhappy that the town was even considering this, that they felt slighted by the whole thing, and they asked the town to consider at least taking that language out of it.
That's all I have, thank you.
Do the other parties have any questions? Mr. Wilson, I think testimony, you stand down. This hearing is in recess until tomorrow morning at 9 o'clock. Please drive safely. 9.